Made Peter Lordship, I beg to mention a matter for listing. It's a two connected writ petition. It was last listed in January. Listing of two connected writ petitions. It was last listed on January.
Writ petitions, why before this one?
Lordship, it is a matter where the respondents have not complied with the order of RERA. So since it's a matter relating to RERA, I mentioned it before your Lordship.
Matter relating to RERA.
Yes, sir.
Then?
It was last taken up in the month of January, where 2 weeks were given to the respondents to file an affidavit.
It's a RERA appeal?
No, Lord.
Then?
But it's a writ petition relating RERA.
So what? It's a CRPIO?
No, Lord. It's a writ petition.
Then, if it's a writ petition, how will this court exercise the jurisdiction? I don't have the roster for that.
Lordship, on the last occasion, this RERA, I mentioned it before FK Mehdi, sir, 2 months back. Sir asked me to check the roster and mention it before the bench was taking RERA matters, RERA appeal matters. That is why I'm before your Lord.
The bench for matter?
Yes, Lord.
Then, I don't have the roster for that. How do I do it? I can't help you. Because I don't have, you see my roster. I'm bound by the roster.
Lordship, since RERA appeal was there, I was under the pretext that
RERA appeal, I can take it up. You convert it to an appeal.
It's a testamentary case, my lord. Testamentary case, my lord. Maybe listed on
testamentary
appeal, my
lord. Go to court, the other court. That appeal is being taken up by that court. There is another bench, no?
Testamentary case, my lord.
Testamentary appeal, you file it there. Yeah.
May please, the concern of the other side, I beg to mention item number 19 and 20 of daily list today, my lord. My lord, my senior Mr. B went for Hyderabad, my lord, for his brother treatment, my lord. I've taken consent from the other side. I think ask about the matter for today.
19 and 20 to be listed in the usual courts.
I'm the PO. The 5. My lord, I have some personal discussion second half.
Huh?
Item number 5. But I have some personal discussion.
Item number 5, these matters, question does not arise.
One of my relative died back, so that's still gone. And so I pray that document take up in the.
Where is Mr. PJ Saikia?
But I will appear in the case. I will do the case. I'm ready to do my document take up in the first case. First up. I'm ready to do it. Take up in the first up.
Okay, we'll take it at the first side. Hey, look. Yes.
To make a of a pending matter for
Withdrawal. Okay. Friday.
125th of
26. And this. Yeah, item 5. That matter where I framed the additional question of law. Yes.
From the last question, the order dated 1/3/2024.
Yes, Mr. Buteka.
Lord, I had the question regarding non-seeking of the relief of recovery of possession. My Lord, for that, my Lord, first ground take is this is not an objection that is born out of feelings. My Lord, because the defendant did not raise this issue of the suit being hit by the proviso to section 34 in the written statement. They of course said that we are not in possession, but that specific is not there. Secondly, my Lord, if your Lordship goes through the plaint, my Lord, in the plaint, my Lord, we have stated the entire episode of dispossession, but perhaps due to an inadvertent omission, that relief was not specifically couched in the prayer portion.
But is
Nevertheless,
it there in your pleadings that you are entitled to the relief?
it is
See,
there.
there is a difference.
Yeah.
In the relief, you may not mention that.
Right.
Then also, if we go by the Corporation of Bangalore, that judgment, one can very well take note of that, 1987. But if it is not there from the pleadings that you are entitled to recovery of possession, then can that be brought into the relief?
My Lord, if your Lordship reads the pleading as a whole, if I
If I read the pleading as a whole, that is what I am saying.
Yes.
You say that you have been dispossessed.
Yes.
But you don't say out there that you are entitled to the possession.
Yes.
If you are entitled to the possession, okay, we can bring it in the relief. But if you are not asking for that, how do I bring it?
My Lord, I'll just refer to the pleadings one. My Lord, page 45 onward. Para 7 onward.
Yes.
That the aforesaid acts, deeds, and conduct of the defendant has cast a cloud of doubt over the subsisting right, title, and interest and possession of the plaintiff over and in respect of the suit land. And as such, the plaintiff filed the suit for declaration of the right, title, and interest and possession over and in respect of the suit land and also for other relief. Thus, the defendants, who are men of dangerous and desperate nature, is making their constant efforts to enter into the suit land and forcibly with ill intention to grab the same by dispossessing the plaintiff and giving continuous threat and intimidation to the plaintiff and its employees with dire consequences, and also of taking their lives in the moment.
So, therefore, in paragraph number 8,
Yes.
you say that you are still in possession.
My Lord.
If
No.
that be so, you are still in possession, then the question of possession, decree for delivery of possession does not arise.
Right, and only difficulty is that board that was installed, which is only the difficulty is that the board was installed of Warrior Club, and for that I have sought a prayer at prayer D at page 47. This is for that stray incident that happened on 4/11/2004, which I have narrated at para 6.
So, save and accept the mandatory injunctions for removal
My Lord.
of the signboard.
Yes.
And also for removal of 2 numbers of wooden posts. No other
Act of
you don't need execution of anything else.
no.
But if you are not in possession,
My Lord, I remain out of possession. My Lord, the decree will be passed as per the release, my Lord. We will have no objection. That was a stray incident which I have narrated at para 6. Well, para
And
5,
the evidence out there of them,
they've
yeah,
said that it is vacant.
it is vacant.
So, my lord, para 5 and 6, my lord, if you're please. That after delivery of possession of the land by the performer defendant, the land is being valid, vacant, and entire land measuring so and so was in peaceful possession of the plaintiff. That for the brevity sake and convenience, the said plot of land is hereinafter referred to as the suit land, fully and particularly described in the schedule hereto B. But surprisingly, on 6/10/2004, defendant number 1 claiming themselves to be secretary and president respectively, along with a malified intention to grab the suit land illegally and forcibly entered into the suit land and prepared to fix a signboard of Warrior Club on the part of the said vacant plot of land. The employees of the plaintiff tried to resist, but the defendants, who were good in numbers, threatened the plaintiff's employees with dire consequences, and by overpowering them, affixed a board and further tried to erect boundary fencing around the suit land to grab the same by dispossessing the plaintiff. But however, the defendants could not succeed to erect the boundary wall on the vehement protest of the employees of the plaintiff. That the aforesaid acts and deeds of the defendants and their associates caused breach of peace and public tranquility of that locality, over and above serious threat to the safety and life of the plaintiff and their employees. Having found no other alternative, the plaintiff on 6/10/2004 filed before the court of so and so a petition for drawing up a proceeding under 144 CRPC against the defendants and their association, which was registered as case number 212, and the learned additional district magistrate in Sukia, after perusal of the record, was pleased to draw up a proceeding under 144 wide order dated 6/10/2004, restraining the defendant number 1 and 2 and their associate from entering into the suit line. That the defendants were men of desperate nature, violated the order of additional district magistrate Tinsuki, and around 4/11/2004 again trespassed into a part of the suit land and affixed 2 numbers of wooden posts, net swings on a part thereof. The plaintiff therefore lodged an ejahar with the officer in charge, Makum Police Station, intimating the violation of the order and prayed for doing the needful. That the plaintiff further on 16/11/2004, in anticipation of further attempt of the defendant, filed another petition in case number 212 of 2004 to convert the proceedings from 144 to that of 145 CRPC, and also for attachment of the under section 146 CRPC to prevent breach of peace and public tranquility in the locality. And accordingly, the learned subdivisional magistrate Yunsukia, while order dated so and so, converted the proceeding under section 145 and also ordered to attach the disputed land.
Yeah, it's okay. Yeah. Now tell me about the first question. Whether the learned first appellate court was justified in decreeing the suit in favor of the plaintiff in spite of the fact that a perusal of Exhibit 4 and 5 shows that the patta and the Jamabandi stands in the name of some other entity other than the plaintiff. And this aspect was not brought, and more so in view of the evidence of PW.
My lord, ultimately, Johar Mal Murli Dharma, that was the greater HUF. These are all just breakaway fractions, my lord.
That is nowhere a part of any, no pleadings, no evidence, nothing.
Lord, that is there in that particular document, my lord, the agreement with his exhibit 20. Now, my lord, like I had argued on the last occasion, my lord, such he does not have any semblance.
But do you have any semblance?
Lord,
Unless you bring it, you are the plaintiff, you are to have the burden to show, yes, you are. The defendant out there in the written statement never claims you to be the owner. His adverse possession case is wrong against you because if he wants to claim adverse possession, the adverse possession has to be against the true owner. So that is wrong. But because of that, can you be said to be the owner of the land?
Lord, exhibit.
Unless that person is there. If you see the exhibit 4A, hello. Exhibit. Okay.
But exhibit 4 is otherwise fine, my lord. Just that 3 onwards, if your lordship sees.
Hey, এইটো ক'ত দিলে নহয় এইবোৰ নহয় এইবোৰ হাজিৰা ফাইল মোক দিয়ক না ফাইলটো দিবি তুমি Exhibit 1 is MS Jaharmal Mulidhar. Appeal proceedings to have been considering the delay and so and so it seems in the above granting mutation in favor of Mickey Douglas.
Oh, my lord, one
Kindly see
onwards, if I may explain.
Exhibit 4.
Is Jawabandi. That is Jawaharlal Muralidhar.
No. Message Jawaharlal Mulidhar and Co.
No, that is the Patta.
Patta. Then
Jamabandi is Messrs. Jawaharlal Muralidhar.
Message Jawaharlal Mulidhar.
It is probably the address Makum Junction.
Now this particular, what is the entry out here on what basis the name was inserted? So unless you correct the patta, the Jamabandi is wrong.
My lord, right from Exhibit 1, if I may just show the sequence. Exhibit 1, first of all, was filed by Messrs. Jawaharlal Muralidhar. That's the name of the plaintiff. My lord, by this order of the Deputy Commissioner, it was held that the appellant herein was the owner. Appellant meaning Jawaharlal Muralidhar was the recorded pattadar, and hence the subsequent mutation in the name of the defendant 3 and 4 are illegal.
Mickey Douglas, Exhibit 1. Mutation order passed by the circle officer dated in mutation case number in granting in favor of Mickey Douglas in the plot of land of under so and so is set aside. The records be corrected accordingly. This is of 9/3/2004.
Yes. Then, my lord, there's another order that is against Chidney Owen Douglas, defendant number 5.
Read this thing and 8/4/2004. See in the Jamabandi, the notings out there, Tinsukia, Zilar,
9/3/2004, my lord.
And what is the second order?
Second order is against the defendant number 5, Chidney Owen Douglas.
No, but whatever may be, it is in the name of NCO. Was a company. Muralidhar was a company.
My lord, it says Jawaharlal Murali.
Messrs. Jawaharlal Muralidhar and Co.
My lord, the Patta says. Jamabandi says Mahar.
No. Forget about the Jamabandi. Jamabandi is only a record.
My lord.
Patta is a document of title.
No, my lord.
Now, if you see the cross of that person concerned, you see, this, all the other documents says as MS Jawaharlal Muralidhar. But Jawaharlal Muralidhar is different from Jawaharlal Muralidhar Properties. It is an association of persons.
My lord, that explanation your lordship finds that exhibit 20.
That I'm looking into. That is an association of persons.
Yes. And there they have narrated how names were changed over the years. My lord, because ultimately.
But there is no mention about that property in this document,
My lord, which property?
this property.
It is there, my lord, all the entire property list was annexed to the document.
Hmm? How by way of an agreement the property can be given to somebody?
My lord, these are family arrangements because ultimately this was
No,
a
no.
large.
Family arrangements can it be given to association of persons?
My lord, it was not given to the association. My lord,
Yes, it is so.
whoever were there, they formed the association.
So how can it be given to the association of persons? And if it is an entity, juristic entity, then only it can file a suit.
Now, my lord, the one who is signed, there are ultimately four owners who decided to form this particular association. Now, among those four, one has filed the suit. My lord. He also has a separate power of
He did
attorney.
not file a suit in the
In-
capacity as a, he has filed it as some manager type.
Yes. Yes.
Then, represented by the managing member come attorney of this association of persons. How can you transfer to an association of persons if you can transfer to an association of persons means to a juristic entity, if it is a juristic entity, then obviously it has to be by way of some other deed. It is a transfer. How can it by way of an agreement be given?
My lord, I'll just, my lord, before you, my lord, to proceed to that question, regarding this Joharmal properties, my lord, today, my lord,
And this aspect of the matter, how can this court at all take into account when there is not a single whisper out there in your plaint? Plaintiff is the absolute lawful owner of the patata, patata and possessor of a plot of land measuring so and so, of dark number so and so appertaining to so and demand. Nothing. There's no mention what how this the plaintiff became the owner. Not a single word out there. Are these evidence which are being referred to as Exhibit 12, 13, whatever may be, are these not beyond the pleadings?
Lord, I filed a suit against the squatter, my lord. And now first of all, I have to initially discharge my initial burden to show that I have at least a better title. Now,
You don't have a better title. First, you have to show your title at all. What is the better title?
There are
There's
pattas.
if you are asking for your are you asking for your declaration of your right?
Yes.
Then it is not a case of adverse possession. The entire case taken up by the learned trial court or the first appellate court is wrong. It can't be a case of adverse possession if you are saying that you are in possession or he is not in possession. Adverse possession will be when it is a suit for recovery based on title for recovery of possession. When your suit is not based on recovery of possession, as you say, then obviously 65 doesn't come into the play. So
No, my lord, what I'm
it becomes a simple suit for declaration. The burden is on you.
and that relief of injunction.
Burden is on you.
My lord, burden, I would say, my lord, I've discharged it by.
Your discharge is not there, nothing else.
My lord, these documents of title, my lord.
Kindly see the evidence of that PW categorically says. Now this person says, your person, what is his name? Some Chokhani, Om Chokhani or something. Who is he?
Sajjan Kumar Sokhani, he is the signing authority, one of the members of that authority.
No, Om Chokhani,
Om Sokhani.
PW5, Om Prakash Sokhani is an association of persons having a area out of the land of so and so. What does he say? M.S. Jahalmal Mullidhar is not an AOP.
He says, my lord, that Messrs. Jawaharlal Muralidhar
Was a HUF.
are Messrs. Jawaharlal and Muralidhar properties.
MS Jawaharlal Mullidhar terminate which is revenue record dot Messrs. Revenue Namot properties or Namot 2 revenue record 9. Let's see that person's concern. Yes, see the cross of this person,
PW, my lord.
PW3.
He is the revenue officer.
Yes, he's a relevant person. Read the cross. Mr.
15/2/2016 তাৰিখৰ পৰা মই ডুমডুমা ৰেভিনিউ চাৰ্কলত CEO হিচাপে কাম কৰি আছো। তাৰ আগতে মই লংকা ৰেভিনিউ চাৰ্কলত আছিলো। বিবাদীয় মাটি কেতিয়াও দেখা নাই। বিবাদীয় মাটি বৰ্তমান কাৰ দখলত আছে মই নাজানো। 15/2/2006 তাৰিখৰ আগত কাৰ দখলত এই মাটি আছিল নাজানো। মই অনা ড্ৰাফ্ট চিঠা আৰু জমাবন্দীৰ সংশ্লিষ্ট পাত্তা দাগত ভুল এটা আছে লাষ্ট সেটেলমেন্টৰ সময়ৰ পৰাই। এই ভুলটো জৱাহৰলাল মুৰলীধৰ পাত্তাৰ নলেজত আছে নে নাই মই নাজানো। বাদীয়ে উক্ত ভুল কাৰেকশ্যন কৰাৰ কেতিয়াও দৰখাস্ত দিয়া নাই। লাষ্ট সেটেলমেন্ট অপাৰেশ্যন 1970 হৈছিল। তেতিয়াৰ পৰা উক্ত ভুলটো COA পাৰ্টিক জনাই নে নাই মই নাজানো। ময়ো পাৰ্টিক এই বিষয়ে জনোৱা নাই। সিডনী ডাগলেছ চিনি নাপাওঁ। তেওঁ বিবাদীয় মাটিত দখল কেতিয়াবা আছিল নে নাই মই নাজানো। মই মাটিত তেওঁৰ অধিকাৰৰ আছে নে নাই মই নাজানো। মই অনা নথিত জৱাহৰলাল মুৰলীধৰ প্ৰপাৰ্টিজ নামেৰে কোনো নামজাৰি নাই। মেছেজ জৱাহৰলাল মুৰলীধৰ প্ৰপাৰ্টিজ বিষয়ে কোনো মাটি নাই বা নথিত এই বিষয়ে উল্লেখ নাই। মোৰ নথিত বিবাদীয় মাটি জৱাহৰলাল মুৰলীধৰ নামত আছে যদিও জৱাহৰলাল মুৰলীধৰ ফাৰ্মটো এতিয়াও এক্সিষ্টেঞ্চত আছে নে নাই মই নাজানো। সিডনী ওৱেন ডাগলেছ বিবাদীয় মাটিৰ মালিক আছিল নে নাই মই ক'ব নোৱাৰিম। মেছেজ জৱাহৰলাল মুৰলীধৰ প্ৰপাৰ্টিজ মানে বাদীয়ে কেতিয়াবা খাজনা দিছিল নে নাই মই নাজানো। গোচৰৰ বিবাদীগণক মই চিনি নাপাওঁ। নামজাৰি দিবৰ কাৰণে দৰখাস্তকাৰীৰ দখলত থাকিব লাগিব। সত্য নহয় যে আজি প্ৰচলিত নথি মতে এক্সিবিট 19খন জাল নথি হয়। ৰেভিনিউ ৰেকৰ্ডত যি পাট্টাদাৰৰ নাম ৰেকৰ্ড কৰা হয় তেওঁৰ মৃত্যু হলে লিগেল এজৰ নাম ৰেকৰ্ড আনিবলৈ হলে পাৰ্টিয়ে পিটিশ্যন দিব লাগে। বিবাদীয় মাটিৰ চৌহদ মই ক'ব নোৱাৰো। বিবাদীক যিহেতু মই চিনি নাপাওঁ। বিবাদীয় মাটিৰ মালিক কোন মই নাজানো।
Kindly read just the last portion of his chief. Prodorsh
3 নং পাট্টাৰ 647, 648, 649, 650, 651, 652, 654 আৰু 655 দাগৰ থকা অংশ জমাবন্দীৰ মতে উক্ত দাগসমূহৰ মূল পাট্টাদাৰ জৱাহৰলাল মুৰলীধৰ হয়। কিন্তু এই পাট্টাদাৰ উক্ত দাগৰ মেছেজ জৱাহৰলাল মুৰলীধৰ লিখা আছে যদিও মোৰ ধাৰণা মতে জৱাহৰ মুৰলীধৰ হ'ব লাগে। নথিত জৱাহৰলাল মুৰলীধৰ ফাৰ্ম বুলি উল্লেখ আছে যদিও জৱাহৰলাল মুৰলীধৰ হ'ব লাগে। So, my lord, ultimately, such a detailed investigation into the name, whether an additional word was added extra or not, my lord. My lord, I have produced the documents of title, the Jamabandi.
Your documents of title is not there.
Well, these are documents of
This,
title. My
this
lord,
there
yes,
cannot be
these
taken
are
documents. It is
clerical
in the name
mistakes,
of
my
some
lord,
court.
which
You should have corrected it.
true, my lord. Just for can I be non-suited just because there are some typographical here and there
Unless
in
you
the revenue record?
you could have very well said all these things, how it has become. You didn't say anything in your plea.
Because I am contesting against a trespasser, my lord.
So what?
My lord, so long as I.
But you are asking for a declaration.
I am, my lord, but
You are asking for a declaration.
my lord, that
The burden is on you.
correct, my lord, but under 35, it's just between us. This declaration is operative against us, as in against.
So what? First of all, against him also, you have to have a better title.
My lord, true. My lord,
Where's
these
your better
my
title?
lord, these documents, my lord, had there been a contest of title, my lord, if these documents would have been countered by documents of better title in so far as they are concerned, then probably such a detailed investigation may perhaps been necessary. But the moment I discharge my initial owners,
Where's the initial owner's business?
by
Now show me that your initial owners will do in a suit for declaration. Initial owners will do. Sue me.
My lord, if it's not
It is absolutely your burden. The weaknesses of the defendant's case is no business. Isn't that, Mr. Gupta?
and my lord, the revenue orders also remain, my lord, which have been passed in my favor, my lord. That the mutation entries of the
It is in the favor of Jawaharlal Muralidhar,
Jawaharlal Muralidhar,
not properties.
not properties, my lord.
Then properties is before the court.
No, my lord, Jawaharlal Muralidhar is before the
Properties. See that. See the plain
or bracket.
bracket.
My lord, will kindly see exhibit 20 for a moment, my lord, when we take.
Why should I look into 20? How do you accuse the evidence of a 20 when you have not led? There's no pleadings to that effect. In fact, if the court had looked into it, it has wrongly done it.
My lord, insofar as pleadings, my lord, I have to concisely state that I am the owner, my lord. Now, what evidence I lead eventually to prove that statement need not necessarily perhaps find place in detail in the plain, my lord. Now, I say Jawaharlal Muralidhar properties is the owner. For
Then?
that, I introduce a patta, which of course has an NCO. I introduce a Jamabandi,
Which has only Jawaharlal Muralidhar.
Muralidhar. And then the revenue, then I exhibit two documents, my lord, which says Jawaharlal Muralidhar properties, and the revenue staff admits that there could be some misdescription in the name. Will that be enough?
Revenue staff categorically says that there is no property in the name of Jawaharlal Muralidhar properties in his property. Categorically.
My lord, if their defense was that there is another entity which is Jawaharlal Muralidhar and
Forget about them. Let us not look into them. First, you are the plaintiff.
This owner's property.
I would have understood if it is a case of adverse possession. That is not a case of adverse possession. It's a simple case for declaration. They ask for adverse possession, that's a different aspect. That is immediate. But otherwise, it's a simple case for declaration.
Ultimately, it will be a comparative since it says
There's no
better
comparative
title.
business. There's no comparative. First, it is your burden out there to prove you are the owner. Properties has no business.
Prove only better title, better than them.
No, not better than them. Where is the question? To me, any law which says that only better title will give you a better right and get a declaration. To me, some judgment to the effect. Only that. Show me that.
Better title.
Better title. There is no concept of better title. Let's shoot for it.
Fetch those authorities which have said that regarding better title. Since it's a contest against, I'll fetch for them.
What? What is this better title business? It cannot be a better title business. It's your burden to prove.
Not true. True, my lord. It's my burden.
That judgment of 2003 or 13, what is that name? What's the name? For declaration, it is the burden upon the plaintiff to prove the weaknesses of the defendant's case has no relevance. What is that judgment?
The plaintiff has to-
What is that judgment?
If we regarding that, my once again, if I may rely on Anatula.
Which one?
Anatula Sudhakar.
What does it say?
Lord, when title would become necessary and when it will be ancillary in issue. Paragraph 13 onward.
Paragraph?
13. Because otherwise I'll have to insist on a molding.
Yes. Then
Then paragraph 14, if
13.3.
13.3 I've seen.
So if
13.3
we
is-
see the paragraph 6 and 7 of your plain, you
Malad.
categorically say that there is a cloud.
Malad, 14 has explained 13.3.
Yeah. What does it say?
We may, however, clarify that a prayer for declaration will be necessary only if the denial of title by the defendant or challenge to the plaintiff's title raises a cloud on the title of the plaintiff to the property. A cloud is said to have to raise.
You yourself admit that there is a cloud.
Malad,
Forget about the other thing.
Malad, a cloud is said to raise over a person's title when some apparent defect to his title to a property or when some prima facie right of a third party over it is made out or shown. An action for declaration is a remedy to remove.
So are you giving up your declaration? The prayer for declaration. See? You are giving up your prayer for declaration.
Malad, then
Declaration is not there. Of right title interest is not there. No confirmation of possession is not there. Because without the declaration, the confirmation of possession does not arise. Doesn't it, right?
it's a suit for simple injunction.
Simply put it for mandatory.
Injunction.
Mandatory.
Mandatory and permanent.
Mandatory.
Mandatory.
Simpliciter for mandatory. Now, in view of the statement made in paragraph number 7, where you yourself have admitted that there is a cloud cast for which it has now been necessitated. In paragraph number 5 and 6, where you yourself say that they have trespassed upon your land and then put up all these things. Now, without a declaration, can you be entitled to a mandatory injunction?
Lord, I would say, Lord, it will come under a suit where declaration, the question of title is only ancillary in issue.
Here it is not an incident. You yourself say that there is a cloud.
Well, but this explains that cloud may not necessarily arise with every act of trespass.
So, you want a mandatory injunction that he wouldn't post to be removed. Nothing else.
And a permanent injunction that he could not interfere.
Permanent injunction for what?
Because I've already said his attempts were afoot to illegally enter into the suit time.
But for that, don't
Yes.
you think that there is a requirement of a declaration?
Well, Lord, if I fall under the
Okay,
previous
then we do one thing. Let me dictate. And in the meanwhile, I will observe that you have given up your claim for your declaration, and then let me teach the judge how it is to be done.
Well, Lord, will
You don't
My Lord
require
will
the declaration.
express what your lordship is
Huh?
contemplating. My Lord will express what your lordship is contemplating so that
I'm dictating the judgment in your presence. You will get it.
My Lord, prayer B and D.
I'll dictate the judgment in your presence. You don't require A.
A, my Lord, again, another aspect of your
A
lordship.
you don't
considered.
require. Now, without A, in view of your self-admission, in paragraph number 7, that there is a cast of cloud. I will
My Lord, my
mention it.
primary argument is that if this is considered to be a cloud, my Lord, I am entitled to a declaration. And this declaration
How?
I seek to derive from
How do
the
you get a
documents of
declaration?
title, barring these
Unless you
typographical
show
errors,
a
my Lord.
document of title, how are you
No, the
entitled?
document of title is there, my Lord. Only the question that perhaps is raising a
Now,
doubt
how
at
do
the
you,
instance of a.
let us assume, you are to show that by virtue of an agreement, the property is being given to a juristic entity. AOP is a juristic entity.
It can hold property, my Lord.
Can an AOP hold the property?
Yeah.
Not now. We are saying about when the suit was filed, not that now an LLP.
My lord, it can hold property if we go by the definition.
Now, if it can hold the property, wouldn't that amount to a transfer? And if it is not a transfer, if it is a transfer, would it that not amount to a conveyance?
It is not a transfer per se, my lord, because these 4 persons had got it by virtue of inheritance. Now they decided to hold it together by forming an AOP. And otherwise, AOP is recognized to be a
So
person.
therefore, it has to be a suit filed on behalf of that person concerned.
True, my lord. Then,
The AOP would not be a juristic entity.
then at best it could be a case of misdescription rather than non-joinder. Because otherwise,
Not
these,
it's a non-joint. It's not a misdescription. It is a plaintiff. The actual plaintiff is not there. When the property is in the name of a company or a firm,
it is not a company or a firm. my lord.
everywhere it is mentioned
It
as
is
company.
and
Somewhere it is mentioned as firm. Your revenue receipt says Jawaharlal Muralidhar firm.
which is why, my lord, I wanted to refer to Exhibit 20, my lord.
20, I've seen that. No use.
20 traces the entire flow, my lord.
20, I've seen the annexure 1 to 20 categorically says out there which are the properties that pata number 39 is
Yes.
brought in. But how do you bring in pata number 39? Is it possible? Can the court take judicial your document of title are those? The suit is filed simply saying that he is the owner. Can the AOP be the owner? And if it is the owner, there has to be a transfer. And can AOP be a juristic entity?
It could be a co-ownership of sorts, my lord.
Because it was an HUF.
It was an HUF.
HUF is a juristic entity.
Yes.
Now, there has been a partition,
Yes, my lord.
and then some properties fell to somebody and all.
Right.
Now, can you have an AOP? Is AOP a juristic entity?
Viewed from another angle, my lord, if it's a co-ownership, my lord, these 5 persons are co-owners, my lord. And the one who's filed it, Sajjan Kumar, is one of the co-owners, my lord. So therefore, my lord, I wanted to persuade that if it's a co-ownership, then any of the co-owners could have come forward, my lord. Now, since Sajjan Kumar is one of the co-owners, my lord, and he has instituted the suit, maybe there is a case of misdescription, my lord. But so long as it's a trespasser, my lord, anyone can sue. And additionally, my lord, the others he also has the authority, or he's the constituted attorney of the remaining 3.
Where is it?
My lord, the power of attorney is an X, my lord.
Exhibited as?
Exhibited as exhibit. I think it will be 90, 15. Vinod Om Prakash Sajjan Ramesh.
Now, how did the property devolve upon them?
My lord, it's given in the recitals, internal page 3 of that document.
Huh?
Internal page 3 of that document.
Now, have you brought on record the family settlement?
No,
Then how do we, on the basis of this recital, can we say that there was a family settlement?
my lord, these are supported by the revenue document again.
The
So,
revenue document
corroborative-
says it's against somebody else.
my lord, that somebody else is no one but the plaintiff, my lord, and
No,
the
the plaintiff is not there. If it is a firm, if it was an HUF, was he a karta? Or did the HUF consist of this person? Show me that.
my lord, what has happened? These 5 were kartas of 5 other HUF. Those HUFs were again part of this Johormal Murlidhar HUF.
Where nothing is
My
there.
lord,
Let us see your chief.
Sajjan Kumar Chokhani, he adduced evidence as PW.
And what is this? He is chief.
He says in the first paragraph that
What do you say about 67 of the Evidence Act? What do you There's not a single whisper in his evidence also about how it happened.
that the origin has not been traced. my lord.
Nothing is there. That he was the karta, how does it become? And all these things, nothing has been mentioned. Can you see 67 of the Evidence Act? Yes, Mr. Gupta. Read it. What is 67? Yes, read it.
Proof of signature and handwriting person alleged to sign.
Huh?
Proof of signature and handwriting of person alleged to have signed or written document produced. If a document is alleged to be signed or to have been written fully or in part by any person, the signature on the handwriting of so much of the document as is alleged to be in that person's handwriting must be proved to be in his.
So merely marking an exhibit could not be sufficient. It has to be proved. But nothing. See
my lord,
how they have exhibited. See this? How they have exhibited. 1 to 15 is a certified copy, certified copy, certified copy. This is the letter of so and so. Is the text receipt, certified copy, copy of the HR, certified copy of the order, so and so, newspaper, so and
my
so.
lord, this entire chapter,
Is the signature, written statement of so and so.
my lord, this entire chapter
Hmm.
is concerning mode of proof. my lord.
Yes.
While they were exhibited, my lord,
Hmm.
there was no objection whatsoever.
Not necessary. It's not the mode of proof. You see, it is not that the document is not admissible. I'm not on that. The document is not admissible, it is not the question. But the question is, can the court appreciate that document, taking into account that you have just marked it as an exhibit, but not proved it?
Sir, he's one of the executants. my lord. He himself is one of
Where is it mentioned that he has signed it?
My lord, this document is not even under.
Not necessary. You see, the question of exhibiting a document is not the question. It has been exhibited. But the question is, have you proved that document? You have not proved that document. Where is it? Can you see his evidence?
My lord, this is not an issue.
It's a certificate.
Fact an issue, my lord.
Not necessary. Because if this court is to go and look into Exhibit 20, Exhibit 15, have you proved that documents?
My lord, exhibit 20, my lord, there's no denial to that, my lord. It's an
How can there be a denial? First of all, there is not a single mention in your plaint
My lord,
You
even
bring
the-
in all these documents.
my lord, these documents are only to show.
Plaintiff has leased out the shoot land to the former defendant about 30 years and it is leased out by MS Jawaharlal Muralidhar HUF. This lease is in question. Have you mentioned that you were a part of the HUF anywhere?
That is not there, my lord, but
Kindly see the chief evidence of the cross. The plaintiff, its status is an association of person. The name of the association of MS so-and-so properties. No any documents have been filed to show that the plaintiff is an association of persons, but we have such document. MS Muralidhar Properties and Muralidhar and Co. are two concerns.
concerns, bro.
MS Muralidhar and Properties was a HUF and after dissolution it became MS
You are
JM
right,
Muralidhar
sir.
and we have family documents to show the conversion of HUF to so and so, but no documents have been filed in the court. So then Utul Borua, who is he?
The employee of the plaintiff.
Number 3 doesn't say anything. Then you come up with number 5. Number 4 is who?
My lord, there is
Huh?
the pro forma.
Mickey Doglop. Number 5. Yes. What does he say?
My lord, he's another
See?
of those.
Exhibit 20 is the certified copy of the agreement of AOP. Yeah. Finish.
My
Is
lord,
this the proof?
my lord, certified copy, my lord, ultimately again, then your lordship will be questioning admissibility.
No, I'm not on that. I'm not on the admissibility. Let it be admissible. But how have you proved it? Then also you need to prove it. Mere marking does not become a that is well settled. How do you prove this?
My lord, this is only to show the formation of the association, my lord. Like
Yes,
we
yes.
annex a resolution of the company.
You categorically, the number 5 categorically admits that there is no properties in the name of MS Muralidhar and properties. See? In his
That
cross.
is borne out of record because the revenue officer has also said.
He also says, your plaintiff also says, your partner.
Well, Lord, it's a case of misdescription. Now,
It's not a
the-
case of misdescription. It is a case of you don't have title. The person, the plaintiff has no business. Wait for another 30 years. Then put them up. I'll have press 2.
my Lord, once again urge, my Lord. That's so such a detailed investigation, my Lord.
100%.
Into
It's a
my
declaration, super declaration. Did you take the leave? When was the evidence given? 2006. No leave was also taken.
my Lord, and these issues, Lord, but these are primarily issues concerning whether the others should have been joined as party.
No, that is not the issue. The issue is he is not up. He has no business association of
my
persons.
Lord, he has 2 revenue orders declaring him to be a recorded.
Only there, not
Mur-
properties. Then how do you show that Muralidhar and properties are one and the same? And that document you have not proved it.
for that comparative analysis as to the question of better title. But if it permit me sometime, I'll try something up.
Only one document shows that you have done something. That is the receipt taken from Doinik Janambhumi. M.A. Jawaharlal Mulya Properties. There is no other document.
No, Lord, given that they have claimed adverse possession, my lord, there is an implied admission of my title also.
The council, adverse possession, when do you bring in 65?
And it's a suit based on title for recovery.
Your own case is, it is not a suit for recovery. And he is not filed a counterclaim. I would have understood he filing a counter and saying that he has title on based on adverse. I would have understood. That is not his case. He, in fact, in his written statement categorically says, look here, the plaintiff has no business over this land. We have been there for the last 30-35 years.
No, my lord, title again, the word title again in one of the judgments have been said that it may not necessarily mean proprietary title. So ultimately, it has come on record that I
The
was
judgment, all judgments are not to be read as illicit spirit. It's said also by the Supreme.
my lord, true, my lord, but
You can't pick one word from here and there and say. The question is, his case is very simple out there. And your case is also very simple. Look here.
my lord, my case,
I gave it to one Mickey Douglas or whatever, maybe for 30 years.
he tried to
And
give-
thereafter, he gave it to these people. And these people are now trespassing. And I have been handed over the possession and now he's disturbing the possession. That's your case.
Yeah.
And he has put some wooden. It's a very simple case. And his case is, look here, I have been here for the last, who is Mickey Douglas or whatever it may be. Me and Raju Das have been there for all this while. And as such, we are in possession of this. We don't recognize who is the plaintiff and all. And somebody told that lawyer out there, you can claim adverse possession. So he uses the word adverse possession without asking for title. So then it squarely fits into that judgment to the Supreme Court, which Mr. Gupta did not bring it, 2014 or 13. Weaknesses of the plaintiff defendant's case has no business in the suit for title. Declaration. The declaration has to be proved without beyond anything by you.
my lord, now, my lord,
Burden is yours to prove it. And you have failed to discharge your burden to the effect that Mulidor properties and is one and the same. Not a single word in your evidence, or also in your evidence also. Nothing is there. Whatever has come out is in the cross.
my lord,
The
regarding
lawyer of the defendant would have been well advised not to say anything, not to cross also to you. And what? Why was that suit dismissed initially?
But it should go down. That he has failed to prove his title.
Hmm?
He has
Failed to prove his title because of that property business, rightly. So it becomes easier for me. Whether the suit is paid for, whether he is the absolute owner, number 4. How does the plaintiff in the plaint have the absolute owner? So the burden lies upon the plaintiff to the plaintiff in support of the contract. Exhibited 3, a compared copy of the exhibit 4, Jolam only and 4 is the recorded contract. Exhibit 4, there are names of yeah was once recorded in the ordinance Pattatar Monitor Makum Junction. As well as the name of the performer was subsequently cancelled as Pattatar. I did not want it. And he referred to Exhibit 19 as certificate of the circle of on Tirukara, it appears the circle officer stated that the entire land was originally recorded in the name of Makum Junction and during return the name was only recorded. But in support of his contention, no return assigned in exhibit. During process of P20, he specifically stated that the name was not recorded in the concern Jamapanti and Patta. He cannot say the plaintiff paid any revenue for the suit land or not. Yeah, on the other hand, the revenue was submitted no data. And yeah, it's one and the same entity. On here, it appears the facts are not stated. However, beautifully written judgment of the trial court. Absolutely. Rightly said. And the first appellate court says it. What? What does the first appellate court say?
Page 15 of
Just on the basis that you claim adverse possession. I think one question is enough for you. Other things are not required. So we dictate.
Lord, just one aspect, my lord. Since ultimately to sue for title, my lord, I have to do it on in the name of the recorded pattadar. My lord. Now the recorded pattadar or the landholder, as is shown in the revenue record, was Johormal property.
When?
My lord, the Jamabandi.
Your Hallman Mulli.
Murli.
Properties is the main problem. Using the word properties has made your entire case.
My lord can construe it to be a suit by Sajjan Kumar alone, my lord. He is competent to.
But show me Sadan Kumar has anything to do with the Jalal Mulidar. Where is it? Nothing is there. I would have considered. At one point of time, I thought of considering it. But how do I do it? You put me in the same position which you put me yesterday, Mr. Oscar had put. He had a very good case. But the thing is the mistake committed by the lawyer, which made everything good, all the problem. You had a good case, but it has been spoiled. They should have, at least the plaintiff should have recited, or even, forget about that. You are saying that, look here, I say that I am the owner out there. Very well. I can further, I only have to say the material facts, nothing beyond that. But the evidence, you have to expand it. Did you say a single word in your chief? Nothing. Except PW5 has said, and that too he did not prove anything. And he in his cross categorically says the Jalal Mulidar properties, Jalal Mulidar are two different aspects. Rotten case has landed in your hands. Issue number 4 rightly decided by the trial. In fact, very right, nicely. And the trial of first appellate court, what did he do? At least you knew about issue number 4, what has happened. Why didn't you improve your case by filing or giving further evidence on the Order 41 Rule 27. We do one thing. You think about the ploy and come up again so that I can remand it to the First Appellate Court. And then you can better your case out. That is the only way out. And then bring me some evidence to the effect and to bring. That is the only way. Otherwise, there is no court, nothing. So you come up with something that this is a case for remand. Once I remand it, then you know what I do. Judgment has to be set aside. No quarrel with that. It has to be remanded back. Then no one can see. Only thing is why I'm otherwise I would not have been bothered because it is a suit filed from 2004. 20 years have passed by. Completely not. Yes, you have a case, but the mistake was committed by your lawyers there. They should have given better particulars. They should have even, when they knew issue number 4 was decided in this manner, they should have come up with a better, something to that effect in their first appellate stage by which they can bring in these evidence or give some evidence to the effect that this HUF and AR, or you bring in the Sajan Kumar aspect of there, something to that effect, or how Sajan Kumar was brought in, that HUF, how did it form? So if you can bring some case for remand, then only you can do something. Otherwise, this exceptional grace, which I am showing it to you because of his bereavement. When? Sometime? Why much time? I've given you the line. Now you have to just come up with some line so that I can remand it. Mr. Gupta will be happy with the remand also, because at the end of the thing, he is saved from the agony of setting aside the judgment, which he will get it. But you have to come up with something. This is the only way. Hello. When?
Lord.
I've spoiled enough time.
3 weeks.
I'll forget.
2 weeks.
The matter having been further heard at length, Mr. B.D. Dekar, the learned counsel appearing on behalf of the respondent, submits that he requires further time for addressing this court on the additional substantial questions of law framed by this court on 21/3/2024. List the matter again on 16th of May. 16th of May. So at the top of the list.
Okay.
Only way out. There you can develop your. Yes, did you find anything?
Lordship, so far we have the sympathy, Lordship, but we have the sympathy on that, Lordship, but we have the policy is not permitted. And therefore,
Policy is
Lordship,
okay, but the judgment out there makes it very clear that, okay, for that period, it's okay, you need not give it. But after that 10 years have gone back, now she will be entitled to, if you don't have that great thing.
great Lordship, the payment, Lordship, is the maximum payment here. And now he is doing the maximum payment, Lordship.
Understood, but 10 years.
But 10 years, Lordship, ROP, after adopting the ROP, Lordship, this 10 years, Lordship,
After that,
yes, after that, Lordship, we are on the ROP now, Lordship, and therefore, Lordship, ROP, he got the maximum payment, Lordship.
at that point,
Yes, at that point.
Yeah.
Thereafter, Lordship,
10 years.
the policy may it
It's not
The-
the question of policy. It's the question of the law.
We have to create the payment.
That day you gave a set of written arguments,
Yes,
no?
yes. And regarding stagnation, Lordship, I have some instruction. of it.
Ah, got it, good. I have got.
Regarding
কাগজখিনি সুধি পেলাই লিখিছে হা? In the backdrop of the above, let this court consider the relevant submissions made by the counsels appearing on behalf of the parties. Mr. B.D. Kaur, the learned senior counsel appearing on behalf of the petitioner, submit that the petitioner has on 31/12/2012 had completed 10 years of continuous satisfactory service in the same grade oblique post and was otherwise suitable for promotion to the next higher post as required under the service rules. However, the petitioner remained stagnant as there was no further higher post to which she could be promoted. It was the further submission of the learned counsel, senior counsel, that the petitioner became eligible for being placed in the next higher grade in the approved pay structure as per her personal scale of pay with effect from 31/12/2012 with effect from 1/1/2013.
But Lordship, she was getting the benefits from 13/9/2013.
Understood. That is your submission.
Yes.
As provided under the /SLAS, all caps, for the employees of AIDC Limited. However, the respondent corporation sat over the matter for nearly 1 year until 13/9/2013, when the slash was partially modified and wrongly applied retrospectively, thereby granting the petitioner a meager raise in her grade pay to 7,600. It was a further submission of the learned senior counsel that a partial modification to the slash was prospective in its operation, that is, with effect from 13/9/2013, and could not have been applied to the petitioner, inasmuch as the petitioner became eligible as on 13/12/2012, 31/12/2012. For the benefit of the slash as it stood then. It was therefore the submission that the respondent corporation, by applying the delaying tactics, unjustly deprived the petitioner of a legitimate right of being granted the general manager's scale of pay, to which she became eligible in all respects as on 31/12/2012, that is, much before the modification of the slash. The learned senior counsel further contended that the Assured Career Progression Scheme (ACPS) dated 25/5/2011 of the state government was never adopted by the respondent corporation. In fact, in the 255th meeting of the Board of Directors of the Respondent Corporation held on 3/8/2012, the ACPS was placed before the board, and after deliberation, the board noted that the slash is more reasonable and acceptable to the AIDC Limited, and decided to continue the slash in respect of the employees of the Respondent Corporation. Under such circumstances, it was therefore the submission of the learned senior counsel that the provisions of the ACPS could not have been applied to the petitioner for depriving her of the benefit of slash as it stood prior to 13/9/2013. It was also the submission of the learned counsel, senior counsel, that the respondent corporation have deprived the petitioner for reasons best known, for reasons other than bona fide. And this very aspect of the matter could be seen from the fact that the respondent corporation had granted the benefit of slash to one S.R. U.C. Burawahai, Deputy General Manager, whose case was exactly like that of the petitioner, by allowing him the pay scale of the next higher post of General Manager via the 27 DPC PAC meeting held on 26/3/2008. Expanding his further arguments, the learned senior counsel submitted that as per clause 3 of the MOU dated 12/9/2012, entered into between the respondent corporation and the state government of Assam, it was the requirement that any change in the pay scale, allowances, perks, or any other service conditions of the AIDC Limited employees having financial implications and which is not as per the provisions of the Assam Service (ROP) bracket rules 2010 shall not be made without the prior approval of the finance department. It was submitted by the learned senior counsel that for giving the benefit of slash in the new grade pay of 7,600, the approval of the finance department, government of Assam, was not obtained by the corporation. It was therefore the specific submission of the learned senior counsel that the said grade pay of rupees 7,500 was only incorporated in the pay scale. 7,600 was only incorporated in the pay scale in order to deprive the petitioner of the higher pay band. Anything else?
Lordship, it has also come to light that as per the instruction of a client, she has not been given any promotion on when she became eligible now also in 2023. Moreover, as the government employees get 3% increment every year as per the ROP rule. Since February 2022, that has also been stopped, saying that you have received the highest pay as per the pay band. Now 3% increment has also been stopped since past 2 years.
No, here somebody says that he has got every month he's getting. I'll record that.
Yes.
Annual increment certificate.
Yes.
Lordship. Point number 4, amount of increment rupees 1,270 instead of 3,790, since the maximum pay in the pay band is 1,10,000. So now even the increment is stopped since past 2 years.
Every year there is an increment of 3%. So now you are getting 1,27,500. You are getting now.
Yes,
That is given up from 2023.
yes, that has been increasing over
Increment from 1st of year. Then from 2023 you are getting 1,27,500.
time. Yes, there should have been an increment of 3% more on this amount, but they have stopped doing it because they're saying this is the ceiling amount on that pay
But
band.
you are going to give the increment
Yeah,
of
right.
3%. That they will give.
Lordship may record it.
Don't worry, let me come up. The learned senior counsel further drew the attention of this court to the fact that not only the petitioner have been deprived of the benefits for the reasons aforementioned, but the petitioner have also been deprived of the 3% increment, annual increment. He submits that with effect from 1st of July 2022, the petitioner have been given 1,27,500 and there has been no further increment of 3% thereafter.
The Lordship permission, Lordship is one more additional submission. Lordship, on the last occasion, the learned counsel for the respondent submitted that the next pay band cannot be given to her because of the educational qualification. She doesn't qualify. Lordship, we have a citation of Honorable Supreme Court where
Yes, what is
paragraph
it?
17, Lordship. It was further observed that fulfillment of educational qualification prescribed under the recruitment rules for the purpose of promotion are not necessary for non-functional in-suit promotion. In other words, educational qualification required for the purpose of promotion is not necessary for grant of in-suit promotion. That is only for extending the monetary benefit where there is no promotional avenue and the employees are likely to be sacked. Their contention that we don't qualify for educational qualification.
No, madam, the problem is not that. The problem is how do you get to our next pay band? Problem is not the grade pay. The problem is the pay band.
Pay
How
band.
do you go to the pay band? That is not what is the subject matter in the judgment. This is for grade C and grade D. So they may be given because the question involved out there was, look here, you are giving him a higher pay band, a grade pay, but this person does not have the qualifications for that. If you see, you are now in the rank of DGM. The earlier was DGM Company Secretary Grade 1. The earlier was DGM Company Secretary Grade 2. Now, Grade 2 to Grade 1, you require certain qualifications. But you can be given that if you are in the same pay band. How do you jump the pay band? That is the problem. Otherwise, there is no problem. The only problem out here that you cannot touch the pay band. So the only resort is this. You knew about all these things at that point of time. There's no other opportunities available.
Where under the protection we'll get the benefits as per slash. That is, after 10 years of service, we'll get the next pay band.
On a lighter
After the
note, madam, on a
modification
lighter note, I am a judge. My salary to that of a chief justice would be different. Okay, I work for 10 years and tomorrow, should I say that now I need to get the salary of a chief justice? I know it. I can't be a chief justice unless I have that, I've been appointed for that. Or can the chief justice who is having 10 years out here can say that, okay, tomorrow onwards I'll need to get it for the Supreme Court judge? No, it's a different post altogether. Here is also the same thing.
But your lordship, there is no post of GM for company secretary.
So you want the creation of a post.
Not a creation of a post, but if there is no post, then the pay scale as
You
per
knew
that
it.
post.
You know it. You can't help it. Can it be helped out there? You know it. If any other post, that is why the increment. The increment has to be given, which is normally the increment. In fact, in other places, it's the DA which is being given. In this increase, now they are giving an annual increment of 3%. The government, the central government gives 6% or 10%, whatever may be. It is being given 3% out here. So this is how it is. You can't help it. This is your fate.
They've been creating the post of GM also for other employees in the department. Lordship. So if they cannot create a post for GM, we are not asking for a post of GM also. We are merely asking for the pay scale. If no,
The learned counsel for the petitioner had drew the attention of this court to the judgment of the Supreme Court in the case of Amresh Kumar Singh and others versus State of Bihar and others, reported in 2023 SCC Online SC 496, and submitted that the question of the qualification, fulfillment of educational qualification, which is one of the reasons for not granting the benefit of the GM's, the pay scale of the GM, the general manager, cannot be a ground, in as much as the Supreme Court had categorically held that the fulfillment of the educational qualifications prescribed under the recruitment rules for the purpose of the promotion are not necessary for non-functional in situ promotions. On the other hand, Mr. J.K. Goswami, the learned counsel appearing on behalf of the respondent corporation, submitted that the question of victimization of the petitioner does not arise, inasmuch as the petitioner joined as the assistant company secretary on 12/7/1995. Thereupon, she was promoted to the next higher grade scale as the assistant company secretary, redesignated as company secretary grade 2, with effect from 12/7/1997. Subsequent thereto, the petitioner was promoted to the post of company grade 1, secretary grade 1, on 31/12/2002. The petitioner thereupon was granted the financial upgradation to the next highest grade pay under slash with effect from 13/9/2013. It has also been submitted that the petitioner have been given is getting the annual increment at the rate of 3% from time to time.
Lordship, regarding 3%, Lordship, we have some policy. Now she is in the optimum highest pay scale in his pay band. Now the statement increment rule is that 3% increment every 2 years. That is all.
Yeah, now it will
Yes.
come up for 2 years.
Yes.
Is getting the annual. Why you are using the word annual then?
And, but
Where is the rule?
yes, office memorandum is there. Relevant portal. I had already said that.
Is getting the increment at the rate of 3% from time to time. The learned counsel further submitted that the memorandum of understanding was entered into between with the government of Assam by the respondent corporation on 12/9/2012. To the said memorandum of understanding, at the time of entering into the said memorandum of understanding, the revised pay structure became a part of the memorandum of understanding, wherein the grade pay of 7,600 was inserted in the pay band of pay band 4 of 12,000, there's 40,000. The Learned Council further submitted that with the insertion of the said grade pay with effect from 12/9/2012, the insertion of the said grade pay of 7,600 with effect from 12/9/2012, the petitioner who was entitled to the next higher grade pay on account of slash with effect from 1/1/2013 became entitled to the next higher grade pay of 7,600, which was duly granted to her on 13/9/2013. Therefore, it has been submitted that the question of victimization of the petitioner does not arise. In addition to that, the Learned Council also submitted that there is an office memorandum with the subject stagnation increment. The said office memorandum is based upon an office memorandum of the government of Assam dated 25th of September 1998, wherein it has been mentioned that whoever reaches the maximum of the revised pay scale shall be granted one stagnation increment on completion of every 2 years from the date of reaching the maximum stage. The Learned Council, further drawing the attention to the said office memorandum, stated that in terms with the said office memorandum, the annual increment, there is a clause 2 which relates to annual increment. In terms with the said clause, all the running pay bands will have annual increment as percentage of the total of the pay in the pay band and the corresponding grade pay. In the new pay structure, the total pay in the pay band and the corresponding grade pay would constitute basic pay. All employees would be entitled to an annual increment of 3% of the basic pay. The date of annual increment in all cases will be the first day of July of the year. Employees completing 3 months and above in the revised grade pay as on first year will be eligible. What you are saying about 2 years?
2 years.
Earlier it has been, this does not say anything about 2 years.
No, but this is for the others.
Others
This
we are
is
not
the
concerned.
exception.
This does not say.
No, this is the exception regarding the highest drawer.
No, that has nothing to do. That has nothing to do. You don't say all this.
No, Lordship, it is the
This is earlier at that point of time when ACP, MACP did not come into the picture. When did slash come in?
Lordship here in this
When did slash come in?
slash Lordship 2002.
Then
2001.
that is why this is not required. And therefore you are giving annual increment.
Annual Lordship for others, not who not obtain the maximum. Now here in this case,
Where is
those
that maximum stated in
this
this
one.
clause 2?
Yes, clause 1 Lordship, it is
Oh,
stated.
What does the clause 1
Yes.
say?
It is stated who may reach the maximum of the revised pay scale shall be granted one stagnation increment.
Where?
Yes, this is the first page, Lordship.
No, first page is not relevant. Second page come here. Increment at 3% shall be paid annually as before, with the stipulation that the maximum stage of a PB will be treated as efficiency bar stage, and when the pay of an employee reaches the maximum of the pay band, he'll be required to cross the efficiency bar in accordance with the provisions of FR 25. When the employee is allowed to cross the efficiency bar, he moves into the next higher pay band. His grade pay will not be changed. Are you saying about this?
Lordship, so far, Lordship. So
Then
far,
in this regard, if this document is important, then this very clause is very relevant.
yes,
We can then put her to the pay band. We can put her to the next pay band then with this, if she crosses FR 25. Read this.
so when the employee is allowed to cross the efficiency bar, he moves into the next higher pay band. His grade pay will not be changed.
Hmm.
So,
So once she crosses there, they will be entitled to C. If C is in the highest maximum stage of the PB, will be treated as efficiency bar stage, and when the pay of an employee reaches the maximum of the pay band, he will be required to cross the efficiency bar in accordance with the provisions of FR 25.
Okay.
FR kon diokto na FR. Madam, we'll have this matter again on Thursday. Mr. B.D. Kumar will be there. And you are a company secretary out there in the respondent corporation. You find out about this thing. If this is there, because what he was referring otherwise is different. Now let's see FR 25. What is required? Where an efficiency bar is prescribed in the time scale, the increment next above the bar shall not be allowed to the government without the specific sanction of the authority empowered to, without increment under Rule 24 or relevant disciplinary rules applicable to the government servant or any other authority whom the government may by general or special order authorize in their behalf. This is the matter again on Thursday. You find out this, huh, madam?
Lordship, you get a copy of the office memorandum.
You take this. Continue. That is relevant.
Obliged.
Then in that regard,
So in this matter, the appellant died, we filed the substitution on 10th of April. May I pray, my lord, this matters may come up on next Tuesday or Thursday, so that the matter can be disposed of, my lord. Maybe substituted and it be hard.
when did the appellant die?
15th of January. 15th of January. Within time, my lord, we have filed it. So I have talked to the other side of my lord. If it comes next week, my lord, you'll also send it.
Mr. D.N. Sahiwala, the learned senior counsel, submitted that respective appeal that the appellant in both the second appeal have expired. Appellant number one.
One.
Have expired. Who is appellant number one?
Jealousy, my lord.
Huh?
Jealousy. Jealousy.
Had expired on 1st of
15th of January. 15th of January.
15th of January 2024. And accordingly, applications have been filed for substitution of the legal representatives of the appellant
On
number
10th
one.
10th of April, my lord.
List the matter again on 1st of May 2024, along with the applications.
Will it come as top of the list? Will it come as top of the list?
No, will come up for orders. Those applications are to be allowed, then only it will happen.
Okay.
Four.
Yes.
Great paper. The concurrent finding of fact finding. The substantive question of law regarding fellow section 90 of the Evidence Act.
What are these exhibit BCT?
That was the Selby minor. Selby.
All.
Selby and the partition did. Family party.
These are registered documents.
No.
None of it.
This is before the party independence of Germany. That's the 1937 and all matter. The documents related to the year 1937 man.
37 sale deed also, then also Transfer of Property Act was there,
Is there, my lord, but
Then
the value is
Registration Act was there,
less than 100 rupees. The valuation was less than 100 rupees.
sale deed.
Before independence man.
Before it. Let's see. How does the first appellate court deal with?
My lord,
It's a concurrent.
concurrent man.
Let's
My
see.
lord, first evidence court did not.
You are the plaintiff.
I am the
I'm the
defendant. I am the defendant.
Who produced those documents?
Defendant. Madam, may I take your dossier petition to the first trial court judgment, madam, because my lord, first appeal court did not discuss much, my lord.
Let us first see the plaint.
Saying says,
Madan Sharma. Madan Sharma is you.
Yes, ma'am.
And these are Komalakanta Sharma and Kolekta Sharma. Who are these? Related.
Yes.
this is a family, my lord, among the brothers, madam.
Suit for declaration and title and for confirmation of partition of the suitlet and further release.
Plaintiff is the title and possession of the respect of 1 beta, 1 kata, 6.5 beta, out of 2 beta, 3 kata, 36 of of and 14 beta and order shares of remain of. Out of the total land measuring 45 plus 35 of. Plaintiff M. accrued state land as a sole heir of the dead father Lakshmikanta Sharma. And yeah, Devi. The dead Sakshi Sharma, dead Sarasaram Sharma, and dead Sharma, Diana Sharma of the village Bali under this court had sitting joint 29 Ahar 1930 Bahar. They had got completely separated from other things that they were living separately as their instruments for the property of the bank. They accepted with their respective house on the state bank. Subsequently, separate pattas were issued in of brothers for the partition also included their debate bank. They continued to enjoy the same terms. They did not participate in separate others to the cultivation for them. They made it by the property and it with but containing after the plaintiff died when it was very young. Mother, elder brother, Sarana Sharma, after mother, as the man under the plaintiff. Then grew up, plaintiff started explaining away from home and account with service, while thus managing the plaintiff, mother's share of land. Plaintiff brother, elder brother, Sarana Sharma, shares purchase product of land and after death, son, dependent number 8712. Also, further other better death number 145 covered with their after this study it accept either take over the position of their other than accept the death of crop. For this crop, but they did and not step up the point. Then the square set you get the plan over for this and but better the
So you are asking for half of the land
Schedule column.
in Schedule 4. Plaintiff is asking.
Yes.
And 1/3 of Schedule 4.
Schedule column. Schedule
Because
column
you
is
happen to be one of the son of one of the
Yes.
three brothers.
Diana Sharma, who is the predecessor. He, according to the plaintiff matter, he had the absolute owner of a total plot of land measuring around 48 bighas.
45 and
48 bighas, 2 kata, 13 lakhs.
Go and go.
Yes.
So
Go
what
is
is
a
go
part of
and all?
column. Go is a part of the schedule column.
And the plaintiff is in possession of
Column.
Golan.
Go.
Now he is asking for what?
For my lord, he is saying that my lord, I have absolute possession over the schedule column. and regarding my lord schedule call and 1/3 possession, 1/3 of the schedule call and.
But the plaintiff is not asking for anything about go.
Go, my lord, I have possession, my lord. So I have only asked for, my lord, separate patta and declaration of my right over the schedule goal.
Then the written statement filed. Who filed the written statement?
That is 10, 11, 12, my lord.
Huh?
You
are who?
I'm defense number 10, 11, 12. I'm one of the brothers, my lord.
And then the written statement of the defendant number 1 to 4 and number 1 Ramesh Sharma. Number 10. Number 10 is Ramesh Sharma.
My lord, they are the legal heirs of my lord Shantiram Sharma and Taranath Sharma. I am the legal heir of Lokshinath Sharma. Our contention was that my lord Doyanath Sharma had 3 sons, Shantiram Sharma, Taranath Sharma, and Lokshinath Sharma. So we.
And who are these? Ramesh Sharma, Probin Sharma, and Dilip Sharma? 10, 11, 12.
Probin,
Ramesh Sharma was the
10, 11, 12. Taranath Sharma.
Taranath Sharma's
Tarnath Sharma successor, my
legal heir.
Okay. So what is your stand in your written statement?
My stand is that, my lord, the land which they have claimed, my lord, some of portion of the land, my lord, has been purchased from the plaintiff, my lord, father of the plaintiff. And accordingly, we have exhibited those documents, these documents of the sale dispatch. That has been discarded and said that although these are coming from a proper custody, but that cannot be accepted as the 30 years old document. That is the only contention in this appeal, my lord.
Understood. Now let us see. You say that you have purchased the land
Purchased the land.
from them.
Yes.
The entire land.
4 biga.
4 bighas.
4 biga, 1 biga.
Out of?
My lord, we are claiming, my lord, 15 bigas. They say that, my lord, with some unregistered sale deeds, my lord, we have transferred 11 bigas of land. By virtue of this unregistered sale deed, my lord.
You have transferred how much?
11 bigas. Their claim, 11 bigha. 11 biga, 1 kata, 18 lakhs.
When? Where is the statement in the written statement?
That is, my lord,
Paragraph 13.
13 onwards, my lord. The statement of saying that the plaintiff father, Lakshmikant's mother, Sunupriya, has not transferred any land under their care to anyone in this manner is not true. In order to repay his loan due to financial problem and to meet his medical expenses, sold his land to the others. He has sold his land to the answering defendant's father, Tarakanta, 4/4/1935 and 38/1941. The defendant number 1 father, Santiram, on 7/11/1941. And this is 28 to 28 who the Assamese calendar,
My lord,
my
the
lord, on
calculation is, my lord, 11, para number 11 of the evidence in chief of the DW4.
How much is the total land as per you?
as per their claim, my lord, there is 40 bigger, 45 bigger.
As per you?
As per me, my lord, that is around
98 bigas.
98 bigger.
Huh?
Total entire land of Dayanath Sharma, my lord, that is original patta that. We said, my lord, the actual title regarding the claim of the plaintiff regarding 3 bigha 4 kata 19 letters on.
Now, how does the trial court decide?
Trial court judgment, my page 15, my trial court judgment. In fact, in trial court, the evidence and outcome has been discussed. In the appellate court, the first appellate court did not discuss anything, my lord.
Wait, where is the trial court judgment?
Page 15, my lord.
1-5.
The main issue regarding the position and issue number 5, my lord.
Issue number 5.
Issue number 5, page 21. Issue relating to the spectrum, whether the plaintiff cited has cited right title interest over the student. The plaintiff have admitted that there was a partition among the three brothers, namely Antiram, Tarakanta, and Lakshmikanta, on 29 Ahar 1337, Bengali year, and Exhibit 15 is the state Vihagnama. Accordingly, these brothers continuously constructed their individual house over their basti land and they started living separately. But the agricultural land was separated among them. It was cultivated jointly by the engaged either other people and crops were divided equally between them. But in the year 1991, when the plaintiff willing to take possession his share of land inherited from his father, the defendant number 10, 11, 12 gave possession to the plaintiff only the land mentioned in schedule law. The plaintiff denied that the father sold away some of his land to other persons from his.
Who is DW3? DW3, who is he?
He is the ancestor of my lord Karanath, my lord.
Huh?
DW3.
He's a cultivating.
Cultivator.
Then who is DW4?
He is the legal heir of my lord. Defender number 10, Ramesh Sharma, son of Ramesh Sharma. Defender number 10.
The father took away about 11 figures of land, but it does not know about the state of the land. On scrutiny of the evidence, DW3 declares that there was supportive evidence for defense of defendant case. So I am saying that there was a doubtful accuracy the evidence was by DW3 and hence not relied upon. So again, DW4 is the affidavit that stated ancestor of the plaintiff and defendant that six are not there as mentioned in the plain. They were led to let Tarakanta and let but Anaram, Hiram, and Moniram attended the coach and said not get again as was parliament. Hence, the remaining three sons, Lakshmikanta, Tarakanta, Santiram remained at parliament and they separated by settlement 29 Ahar 1937. 1932. As part of the settlement of the brother got granted property of
Who exhibited this exhibit B, C, D, E, and F?
DW Foreman. DW Foreman.
DW4 exhibited.
Yes.
How? Who is he? Did he submit a written statement?
His ancestor, my lord,
Did he submit a written statement?
number 10, my lord.
He was number 10. He is the son of Taranath.
Taranath.
DW1 and 2 is gone. DW3
He
is
independent
not
now.
relevant.
DW4 is the successor of Taranath
So he is one of the defendants who submitted a written statement.
Yes.
So he produced those
document.
the documents D, B, C, D, E, F. Okay, then
ultimately, my lord, in the paragraph last part, my lord, court held, my lord.
Where production without some corroborative evidence is not entitled to any weight. Section 90 is very much clear. The court may presume that the documents purported to be real, old or genuine, not that it may assume them to be still is exhibited by the. So this was not taken into account.
Yes, and this is the substance.
Now let's see how does the first appellate court deal with it.
First appellate court did not discuss much, my lord, as per the trial court judgment. Corroborated with same, my lord, and said that it nothing, my lord.
Let's see the cross of DW for A. Under what circumstances under section 91 can take that documents? Any
Okay.
judgment?
Yes. Regarding, my lord, first two parts, my lord, section 90, my lord. Part, my lord,
You have
first-
any judgment?
yes, my lord.
Yes. Give it. You were not born. DW4 was not born
Not for-
when these documents were there.
But we have the custody of those documents.
How? How did you prove your chain of custody?
Because I am the, my lord, son of the defendant number 10, my lord.
Huh?
First of all, the trial court did not deny that it has come from the proper custody, my lord.
Hmm.
The section 90 says that there are two parts, my lord. One, they must be come from proper custody,
Hmm.
and it has to be 30 years old document. These two parts has not denied by the trial court as well as the appellate court. But trial court says, my lord, although these come from the proper custody, but it cannot be corroborated with the other document, other evidence, my lord. That's why it was rejected the failed it, my lord, as exhibited.
How did you prove exhibit A? Understood? You brought in. Presumption is there. Then nothing is required. How is this relevant, this document, this judgment? Lakshmi Borwa? How was the cross of DW4 was done?
Okay.
Exhibit and how did he have the custody of these documents in his evidence? As you mentioned,
But in custody matter, the state matter, my father was purchased as a state.
how did you have the custody? You must have stated somewhere you were not born.
As per ancestor matter, would have the custody.
It's very nice hearing from Mr. Siladitya about this.
In this part,
I am not on that. I'm strictly on the basis of evidence. As to where have you mentioned about your custody? I'm coming at 2 o'clock.
the evidence part, AW4. Was mentioned. Paragraph 12. Paragraph 12. That the documents submitted are all from more than 30 years old and in the custody of Sarakasa and Santiram, the forefather of the defendant. Evidence, my lord, paragraph 11. We've explained about it. How the event was full.
Let's see the cross.
Cross part.
Read the cross of DW4.
Entire cross part.
Yes.
মোৰ পিতা আৰু ভূপা আৰু তেওঁৰ বন্ধু হিচাপে তেওঁৰ হৈ মই এই গোচৰৰ প্ৰতিদ্বন্দ্বিতা কৰিছো আৰু বৰ্ণনা দিছো। মোৰ আটা গ্ৰেণ্ডফাদাৰ তাৰাকান্ত 6জন ভায়েক আছিল। হাতী লক্ষীকান্ত আৰু তাৰা গাঁৱত আছিল মিলি গাঁৱত আছিল আৰু বাকী কেইজন অন্য ঠাইত স্থায়ীভাৱে বাস কৰিছিল। বালি গাঁৱৰ তেওঁলোকৰ সম্পত্তিৰ অংশ নাই। তাৰা শান্তি আৰু লক্ষীয়ে ফাৰাকাটি যোগে পৃথক হৈছে। গোৱাৰদল গাঁৱৰ থকা আমাৰ ভাগৰ মাটিখিনি বিক্ৰী কৰিছে মোৰ দেউতাক কিছু বছৰ আগতে। বালিগাঁৱত থকা আমাৰ অংশৰ মাটি বিক্ৰী কৰা নাই। That is the scheduled land. লক্ষীকান্তৰ মৃত্যু মোৰ জন্মৰ বহু বছৰ আগতে হৈছিল। পত্ৰৰ 11 নং দফাত লক্ষীয়ে মাটি বিক্ৰী কৰা বুলি লিখিছে। যদিও উক্ত সকলোবিলাক দলিল আদালতত দাখিল কৰা নাই আৰু দাখিল কৰাৰ বাবে মই আদালতৰ কোনো তদবিৰ লোৱা নাছিলো আৰু তাৰে কেইখনমান দলিল অৰ্থাৎ তাৰা আৰু শান্তিৰ দলিল দাখিল কৰিছো কেইখনমান দলিল। এক্সিবিট 22 জমাবন্দীৰ বালি ইটা তাৰাকান্ত শৰ্মাৰ নামত 2 নম্বৰত লিপিবদ্ধ হৈ কৰোঁ। লক্ষীকান্ত নাম 4 নম্বৰ পট্টাদাৰ হিচাপে লিপিবদ্ধ হৈ আছে। এক্সিবিট 23 তাৰাকান্তৰ নামত 4 নং পট্টাদাৰ হিচাপে এক্সিবিট 25 লক্ষীকান্তৰ নাম 1 নং পট্টাদাৰ হিচাপে লিপিবদ্ধ হৈ আছে। বাদীৰ মাতৃৰ নাম বসুমা প্ৰিয়া এক্সিবিট 26 বাদীৰ মাতৃৰ নাম 7 নং পট্টাদাৰ হিচাপে লিপিবদ্ধ হৈ আছে। 2 নং পট্টাদাৰ মৃত্যু হোৱাৰ তেওঁৰ স্থলত বাদীৰ মাতৃৰ নামত উত্তৰাধিকাৰী স্থলে নামজাৰি হৈছে। লক্ষী আৰু বাহিৰে ৱাৰিছ হিচাপে মদনে তেওঁলোকৰ সম্পত্তি দখল ভোগ কৰি আছে। মাটি আৰু মোৰ আটা তাৰাকান্ত আৰু লক্ষীৰ যৌথভাৱে কিনিছিল যদি মই নাজানো। মই জনাত বালিৰ দখলত 4 বিঘাৰ অলপ বেছি মাটি আছে। শান্তিৰামৰ আগৰ মাটিখিনি তেওঁৰ ৱাৰিছগণে বহু বছৰ আগৰে পৰা প্ৰথমে দখল কৰি আছে পৃথকে দখল কৰি আছে। শান্তিৰামৰ পুতেক 4জন হৈছে প্ৰভাত ৰমাকান্ত ত্ৰৈলোক্য আৰু গংগা। গংগা আৰু প্ৰভাতৰ মৃত্যু গোচৰ কৰাৰ আগতে হৈছে। ত্ৰৈলোক্য আৰু প্ৰভাতৰ পুত্ৰ শৰৎ আৰু দ্বিজেনে এই গোচৰত বৰ্ণনা দিছে। প্ৰভাতৰ পত্নী ভানুপ্ৰিয়া আৰু 5 নং বিবাদীৰ বৰ্ণনা দিয়া নাই। গংগাৰ ৱাৰিছগণে বৰ্ণনা দিয়া নাই। এই মোকৰ্দমাত মোৰ আটা তাৰাকান্ত মই সৰু থাকোতে মৃত্যু হৈছে। তেওঁৰ পত্নীৰ ৰাধা দেৱী মৃত্যু হৈছে। মৃত্যু 1985 চনত হৈছিল। লক্ষীকান্তৰ মৃত্যু বিভাগনামা হোৱাৰ পাছত হৈছে আৰু সেই সময়ত বাদী নিজেই সৰু আছিল। মই
সত্য নহয় যে লক্ষ্মীৰ মৃত্যুৰ পাছত বাদী নাবালক থকাৰ বাবে লক্ষ্মীৰ মাটিৰ মূৰ আটা তাৰাকান্ত পৰিচালনা কৰিছিল। সত্য নহয় যে বেলেগ হোৱাৰ পাছত উমৈহতীয়াভাৱে খেতি কৰা হৈছিল আৰু ফচল ভাগ কৰি লোৱা হৈছিল। সত্য নহয় যে 1991 চনত যেতিয়া খেতি চপোৱাৰ অন্তত 1992 চনৰ পৰাই বাদীয়ে বাদীৰ অংশৰ জমি পৃথকে দখল কৰা
So there is no cross on these. Yes, what do you say?
Yes, my lord. But I'll just sum up, my lord. Plaintiff
You don't
filed
need
this-
to, you start it.
Yes.
That was coming. Yeah, tell me.
Plaintiff filed this suit claiming right title interest over schedule colon, which is a part of schedule colon. Schedule colon consisted of around 48 bighas, 2 kata 13 lata. So he said that, my lord, out of schedule colon, my lord, he is entitled to 1/3. So basically, my lord, that will be 15 bigha, 1 kata, 6 lata, 10 kani. Defendants, my lord, say that, my lord, we have already sold 11 bigha something, my lord. If your lordship will kindly see the evidence in chief of DW4, my lord, they have given the calculation, my lord. So by virtue of several sale deeds, my lord, they have, my father has sold this 11 bighas of land. So they say that, my lord, I am entitled to only 3 bigha, 4 kata, 11 lasas of land. Now the thing is that, my lord, if we take into account section 90, my lord, section 90 says that, my lord, if any document is 30 years old and is produced from proper custody, my lord, then the signature, the handwriting, attestation and execution will be presumed to be of that person who has done it, my lord. Now, my lord, in this case, my lord, but the thing is that, my lord, the contents will have to be independently proved, my lord. Since in this case, my lord, the plaintiff has categorically stated that his father or his mother has never executed any, my lord, sale deeds, my lord. So definitely, my lord, the court thought that, my lord, some further evidence was required. And if your lordship will see, neither the WS nor their evidence consisted of any particulars regarding, my lord, whether the DAG number, patta number, boundary of this lands, my lord, nothing is mentioned, my lord. So-
But you see, the trial court did not deal with that aspect of the matter. First appellate court didn't do anything.
Yes.
But the trial court did not deal with that aspect of the matter in that manner.
No, my lord, that is why, since we have denied of execution of any sale deeds, my lord, that is why for proving,
No, you have denied. You have not, there is no counterclaim.
yes, because, my lord,
There is no counterclaim
No
out there
counterclaim.
for which you have any pleadings as regards the denial.
no, if
You have not even cross-examined him on these documents.
then, my lord, if your lordship will see, they have exhibited B, C, D
Where did you deny?
in our plate, my lord.
You knew your plaintiff. Thereafter, the thing came out that these are the documents on which the sale has taken place.
No, here,
Isn't it required that you had to cross-examine them?
yes, my lord, in our cross
That these documents were not at all executed, nothing was there, then only the court could have come to an opinion, okay, yes, there is no quarrel that this is discretionary presumption, but when a discretionary presumption is there, the court ought to have done it in a proper manner.
yes, even otherwise, my lord, they have exhibited, my lord, 5 sale deeds, B, C, D, E, and F. B, C, D are the alleged sale deeds, my lord, which we have.
Why are you saying alleged? You have not even put a question on the cross-examination.
But even otherwise, my lord, they have said that, my lord, by virtue of BCD, we have transferred 4 bigha 1 kata of land to Taranath Sharma and Santiram Sharma. So even if we admit that part, their initial claim was that around 11 bighas of land. Now regarding E and F, my lord, those sale deeds, my lord, were purportedly made in favor of some other persons, my lord. So how it landed in their custody, my lord? So nothing is there. How the sale deed number E and F were exhibited by the DW4, because if your lordship will see, the para number 11,
They were sold 4 bighas, 1 kata, 1 letter, Taranath and Santara.
Santiram, yes. And
Then to the father of the defendant number 13, 2 bighas, 17 letters.
yes,
To the father of the defendant number 18, 19, and 20, 1 bigha. Yeah. Gandhiraj Karma, 1 bigha. By the plaintiff himself to Pali Haloi, 1 bigha.
yes.
So are you admitting to those sales?
No, my lord, he has
Why
to-
haven't you cross-examined him?
but he has, but categorically stated that he has not submitted some other sale deeds, my lord, and he has not taken any steps to call for the same. So even if we admit some of these, my lord, then also, my lord, their initial claim.
No, at there, you see, the question is, you may have a case.
Yes.
As regards the other land, but not as regards 4 bighas, 1 kata, 1 lecture,
Maybe.
where they are claiming it.
Yes.
So it is for the first appellate court to look into that aspect of the matter. I think this is a case for remand. Because the first appellate court didn't do anything.
But my lord, these documents came up for the first time before us during the evidence of the defendant witness, my lord. Before that, my lord, these documents were never.
Why didn't you put it at the object?
Probably,
At the
my-
time of cross-examination, you could have put it under object. Did you put it? No.
That has not been said.
Well,
But even otherwise, my lord, presumption is discretionary, my lord. So that is
understood.
why-
Presumption is discretionary, but you see, kindly see the illustration. Illustration to section 90. Illustration A. And see the explanation.
If a contract is contained in several letters, all the letters in which it is contained must be proved.
What is the explanation say?
Documents are said to be in proper custody if they are in the place in which and under the care of the person with whom they would naturally be. But no custody is improper if it is proved to have had legitimate origin or if the circumstances of the particular case are such as to render such an origin probable. That is the explanation.
Kindly see the first
Illustration. ma'am. A has been in possession of landed property for a long time. He produces from his custody deeds relating to the land, showing his title to it. The custody is proper.
You're admitting that he is in possession. He has produced the document.
But my
You
lord,
have not even denied in your cross.
yes, cross we
Then-
have not challenged. But the thing is that, my lord, since there is a general allegation, my lord, regarding the execution, so the court, since it's a presumption, there is a discretionary, that is why, my lord, the court sought for further proof, further supporting
If
evidence.
it is discretionary, the discretion has to be exercised in the proper manner.
Yes.
What did the trial court do? See what the trial court did. The defendant side, though exhibited sale deeds D, E, F, and have produced from proper custody, and the said documents are more than 30 years, but their value as evidence must be deposed upon the corroboration derived from external circumstances. Mere production without such corroborative evidence is not entitled to any aid. Wait, what is this? What is this corroboration required further? When the document of title is there, these are documents of title. What are the unit? What are the things which are dispensed with? First, the person that there is a proper execution, that you cannot question. There is a proper attestation, you cannot question. There is a registration, if it is there or not, you cannot question. Only the question is as regards the contents.
Content.
You did not put the cross. If you have raised the cross out there, the court would have asked them, okay, then you prove it. You didn't cross at all. And what other corroborative evidence is required?
That way, my lord, they have not also cross-examined our witnesses.
What is there to cross-examine your witness for that? These are the documents. Have you mentioned anywhere anything? No. Then you didn't put under objection these documents also. Therefore, I think this is a case we'll remand it. Because this will require the first appellate court to decide this aspect.
As regards 4 bigha 1 kata. As regards 4 bigha 1 kata.
No, the court has to properly decide, taking into account that these documents are 30 years old, and as such, the presumption which have been the the rejection of those documents is wrong. The court couldn't have done it in such arbitrary manner, and for the first appellate court, it was the duty to look into that aspect of the matter.
Documents are there in the record.
This, huh?
The original documents are there, but
I've seen it. Original documents is very difficult to understand and read.
it is there.
But are those documents all, when the value of the property is below 100? The instant appeal under section 100 of the Code of Civil Procedure is directed against the judgment and decree dated where is the judgment? Page,
7.
huh?
Page 7.
Judgment and the decree dated 7/5/2007, passed by the Court of the Civil Judge Nalbari in title appeal number 8/06, whereby the judgment and decree dated 16/1/2006, passed by the learned Civil Judge Junior Division number 2 Nalbari in title suit number 5/1995, was affirmed. This court, by an order dated 23/11/2007, admitted the instant appeal by formulating the following substantial question of law. It was today. Next. The question therefore arises, the instant appeal, therefore, this court is of the opinion that for ascertaining as to whether the said substantial question of law so formulated arises in the instant appeal, this court, for the purpose of deciding as to whether the said substantial question of law which have been formulated is involved in the appeal, is involved in the instant appeal, finds it relevant to briefly take note of the facts leading to the filing of the instant appeal. From the materials on record, it reveals that the respondent herein, respondent is Madan Sharma, is alive.
Yes.
Respondent herein, as plaintiff had instituted a suit seeking declaration of right, title, and interest, semicolon, for confirmation of possession upon partition of the suit land and for other reliefs. The brief facts leading to the filing of the suit was that one Dayaram Sharma, what is the name? Dayanath Sharma, since deceased, was the original owner of various plots of land which have been specifically described in Schedule 4 and Schedule 4. It is the case of the plaintiff that late Dayanath Sharma had 3 sons. That is, late Santi Sharma, late Taranath Sharma, and late Lakshmikanta Sharma. The plaintiff's father was late Lakshmikanta Sharma. During the lifetime of late Lakshmikanta Sharma, and his 2 brothers, there was no dispute as regards the possession, as regards the rights and possession of the scheduled lands. However, pursuant to his death, pursuant to the death of late Lakhikanta Sharma, the plaintiff was only in possession, remained in possession of the scheduled Gaul land, which is a part of the scheduled Gaul land. Accordingly, the plaintiff filed a said suit seeking the declaration of his title in respect of half of the scheduled Gaul land, that is an area measuring 1 bigha, 1 katha, 16.5 lecha out of 2 bighas, 3 katha, 13 lechas, and further 1/3 share of the land in schedule Ko, that is 14 bighas, 1 katha, 8 by 1/3 lecha, and other reliefs. The said suit was registered and numbered as title suit number 5/1995. Although there were various defendants, but the defendant numbers 1, 2, 3, and 4, as well as the defendant number 10, 11, and 12, jointly submitted a written statement. In the said written statement, it was stated, amongst others, that a plot of land measuring 4 bighas, 1 katha, 1 lecha, isn't that? Four bigha, 1 katha, 1 lecha was sold to late Taranath Sharma and late Santiram Sharma. By the father of the plaintiff, late Lakhinath Sharma, by executing various deeds of sale. In addition to that, it was also mentioned that the father of the plaintiff, as well as the plaintiff, had sold other plots of land, and as such, out of 15 bighas, out of the land which have been claimed by the plaintiff in the suit, 11 bighas, 1 katha, 18 lechas of land was sold by the plaintiff and as well as his father. The remaining entitlement of the plaintiff, therefore, was only 3 bighas, 4 kathas, 19 lechas, which the plaintiff was duly possessing. On the basis of the said pleadings, the learned trial court framed as many as 6 issues. Issue number 5 is relevant in as much as the said issue relates to as to whether the plaintiff had right, title, and interest over the suit land. The plaintiff exhibited 2 witnesses in support of his claim and exhibited some documentary evidence. The defendant side also examined 2 witnesses in their favor and exhibited some documents. Amongst the various documents which were exhibited, Exhibit A pertains to Vibhagnama. Exhibit B, sale deed dated 38/1941. Exhibit C pertain to sale deed dated 4/4/1935. Exhibit D pertain to sale deed number dated 7/11/1941. Exhibit E pertain to sale deed dated 28 Uha, Bangla year 1340. Exhibit F, sale deed dated 23/4/1944. Exhibit F, full stop. It is relevant to take note of that these exhibited documents, that is Exhibit A to F by the defendants, were 30 years old, and the said documents were exhibited without any objection. The learned trial court, while deciding the other issue by the judgment and decree dated 16/1/2006, decreed the suit, passed the preliminary decree, thereby declaring the right, title, and interest in respect of the suit land to the extent of half share in the scheduled core land and 1/3 share in the scheduled core land. And thereupon send the said preliminary decree to the collector, Nalbari, for effecting partition in accordance with the Assam Land and Revenue Regulations 1886. Being aggrieved, good stuff. At this stage, it is very pertinent to mention that while decreeing the suit, the learned trial court decided the issue number 5 in favor of the plaintiff. It is pertinent, it is apposite herein to take note of that the learned trial court disregarded the exhibit B, C, D, E, and F. After holding that the said documents were produced from proper custody and the documents were more than 30 years, on the ground that the said documents required corroboration from external circumstances. Being aggrieved, the appellants hearing preferred an appeal before the court of the civil judge, Nalbari, which was registered and numbered as title appeal number 8/06. The learned first appellate court, by the judgment and order dated 7/5/2007, decided the appeal and dismissed the appeal by confirming the judgment and decree passed by the learned trial court. At this stage, this court finds it very pertinent to take note of that the learned trial court, learned first appellate court, did not even care to frame the points of determination or decide the appeal in accordance with the provisions of Order 41, Rule 31 of the Code of Civil Procedure 1908. Be that as it may, the instant appeal has been filed, which have been admitted by this court by the order dated so and so, by formulating the substantial question of law as quoted herein above. In the backdrop of the above, let this therefore take note of as to whether the said substantial question of law which have been formulated duly is involved in the instant appeal. This court have no, yeah. For deciding the say substantial question of law, this court finds it relevant to reproduce the provisions of section 90. Evidence a confirm. Of the Indian Evidence Act 1872, along with illustration A, as hereinunder. Explanation, then illustration A. B to B. Section 90 of the Evidence Act, Indian Evidence Act, what Act of AR will be, Act of 1870 of the Evidence Act, is based on the legal maxim nemo that we non habit bracket no one gives what he has not got inverted comma and nemo plus juris tribut quam ipsi habet bracket no one can bestow or grant a greater right comma or a better title than he himself. This section does away with the strict rules as regards the requirement to prove which are enforced in the case of private documents by giving rise to presumption of genuineness, comma, in respect of certain documents that has reached a certain age. The period is to be reckoned backwards from the date of the offering of the document and not any subsequent date, that is the date of the decision of the suit or appeal. Thus, the section deals with the admissibility of ancient documents, comma, dispensing with the proof as would be required in the usual course of events in a usual manner. The Supreme Court, in the case of Lakhi Borua versus Padmakanta Kolita, reported in 1996, 8 SCC 357, observed that Section 90 of the Evidence Act is found on the necessity and convenience because it is extremely difficult and sometimes not possible to lead evidence to prove handwriting, signature, or execution of the old documents after a lapse of 30 years. In order to obviate such difficulties or improbability to prove execution of an old document, Section 90 has been incorporated in the Evidence Act, which does away with the strict rule of proof of private documents. The presumption of the genuineness may be raised if the document in question are produced from proper custody. It is, however, the discretion of the court to accept the presumption flowing from Section 90. There is, however, no manner of doubt that the judicial discretion under Section 90 should not be exercised arbitrarily and not being informed by reasons. Paragraph 14 and 15 of the said judgment being relevant is reproduced herein under. In the instant case, it would be seen that the DW4 had adduced, had exhibited the exhibits A, B, C, D, E, and F. In his evidence on affidavit, the DW4 had categorically stated that the said documents were in the custody of the heirs of Tarakanta and Santira, who are the ancestors of the DW4. This court have also perused the cross-examination of the DW4. None of these exhibited documents were put under objection, or the admissibility of the same was questioned. In fact, the cross-examination of the DW4 reveals that the plaintiff side did not even cross-examine the DW4 on the contents of the said documents. In the backdrop of the above, let this court now take note of as to how the learned trial court dealt with the said aspect of the matter, inasmuch as the first appellate court merely confirmed the said findings without expressing any reasons. The learned trial court, while deciding the issue number 5, observed categorically observed that the defendant side, though exhibited the sale deed, exhibit B, C, D, E, and F, and have produced from proper custody, and the said documents are more than 30 years old, but their value as evidence must be deposed upon corroboration derived from external circumstances. It is for that reason the learned trial court rejected the said documents, observing that the learned trial court was not inclined to draw the presumption, the statutory presumption. Full stop. The reason so assigned in the opinion of this court is totally arbitrary, inasmuch as the said documents were not only 30 years old, more than 30 years old, the said exhibits, being exhibit B, C, D, E, and F, were not only 30 years old, more than 30 years old, comma, the same were produced from proper custody, as would be seen from the evidence of the defendant, number 4, as well as the same would be apparent from a reading of the explanation to section 90 and illustration A of the said section, as already quoted here in above. This court have also duly, this court further finds it that the observations made by the learned trial court that the said documents required further corroboration is not at all justified, taking into account that there was not even any inasmuch as there was nothing pointed out during the cross-examination challenging the contents of the said documents. Not to speak of raising any objection to the admissibility of the said documents. In the backdrop of the above, if this court now takes note of the judgment passed by the learned first appellate court, it would be seen the learned first appellate court merely confirmed the said findings, holding inter alia that the learned trial court had discussed the issue number 5 in an extensive way. At this stage, this court finds it very relevant to take note of the judgment of the Supreme Court in the case of Purushottam Santosh Hazare. Case of Santosh Hazare versus Purushottam Ram Tiwari, reported in 2001 PSCC 179, wherein the Supreme Court categorically delineated as to how the first appellate court should decide a first appeal. It was categorically observed by the Supreme Court that the first appeal is a valuable right of the parties, and unless restricted by law, the whole case is therefore therein open for rehearing, both on question of fact and law. The judgment of the first appellate court must therefore reflect its conscious application of mind and record findings supported by reasons on all issues arising along with the contentions put forward and pressed by the parties for the decision of the appellate court. The Supreme Court further, though observe, the Supreme Court in the same judgment, though observe that the appellate court, agreeing with the view of the trial court need not restate the effect of the evidence or reiterate the reasons given by the trial court. And the expression of general agreement with reasons given by the court, decision of which is under appeal, would ordinarily suffice. However, the Supreme Court categorically observed with a note of caution that expression of general agreement with the findings recorded in the judgment and the appeal should not be a device or camouflage adopted by the appellate court for shirking the duty cast on it. In the instant case, this court, having perused the impugned judgment and order passed by the learned judgment and decree passed by the learned first appellate court, finds it relevant to observe that the learned first appellate court failed to discharge the duty as mandated under Order 41, Rule 31 of the Code, and had merely and shirked its duty which had been cast upon it by law. This court further is of the opinion that under such circumstances, in the opinion of this court, the impugned judgment and decree passed by the learned first appellate court, that is dated so and so, requires to be interfered with, and therefore the same is set aside and quashed. This court further is of the opinion that as the appreciation of Exhibit B, C, D, E, and F was not done properly following the mandate of Section 90 of the Evidence Act, the same requires to be again appreciated by the first appellate court, and taking into account the limited scope available with this court under Section 100 of the Code, this court finds it a fit case for remand of the entire appeal to the learned first appellate court for deciding the said appeal afresh by duly taking note of the exhibits B, C, D, E, and F. Accordingly, this court, exercising the powers under Order 41, Rule 23, A, remands the instant appeal back to the learned trial court, back to the learned first appellate court, that is the court of the civil judge, Nalbari, for deciding the said appeal in terms with the observations and directions given herein above. This court have also taken note of that the instant suit was filed in the year 1995. And as such, an attempt may be made by the learned first appellate court to dispose of the same at the earliest. Next. Taking into account that the parties are represented before this court, comma, They are directed to appear before the learned First Appellate Court on 3rd of June 2024, so that the said First Appellate Court can proceed with the said appeal in accordance with law. Next. The judgment and decree, for the sake of clarity, the judgment and decree dated so and so is set aside and quashed, and the appeal is remanded back to the trial court, that is the court of the civil judge Nalbari. Next. The registry shall forthwith send back the records along with a copy of the instant judgment to the learned trial court, learned First Appellate Court, so that the same can be taken up by the learned First Appellate Court on the next date so fixed by this court.
Highly obliged.
Yes, what is this?
Mr. appeal.
Hmm.
There, my lord, the section 34, my lord, charge is not considered, my lord. Page 31. The depth of considered, my lord, in fact, 34, section 34, my lord, he has quoted, but the main contention of fraud and misrepresentation has not been considered. Fraud misrepresentation has not been mentioned here, and he said that it does not come with the part of it. Page 35, my lord, he has quoted section 34. Here, my lord, actually forgery has been done, and a charge sheet has been filed against the person.
Yes, what is your ground?
Well, ground is fraud and misrepresentation the main, my lord. 153, my lord, 152, we have submitted it, my lord. 152, my lord.
Yes.
152 is the Russell submit, my lord, that they have made forgery of the documents. My lord, before the district judge, we have submitted.
What forgery?
But remember, the documents has been forged, my lord. The well, this is trading, my lord, on exchange, here. Stock. So the appellants, my lord, one agent was there in Marketa. They have made some old documents with the son of the mother lady, and on that basis they made something. And that is why, my lord, a charge sheet has been filed against the respondent, my lord, where he was absconding. Thereafter, he approached the Calcutta High Court. Calcutta High Court directed that no question you appear before the court. Then he was joined the bar court.
Who?
The respondent number one.
Here. Respondent number one was behind bar.
Yes. Calcutta High Court order was there, my lord.
Now, what was the dispute before the arbitrator?
Arbitrator dispute is, my lord, they say that without their knowledge, some transactions were made and they have made some demand. But he is to
Who are you?
Well, I'm the company, my lord, dealing with the stock. I'm a member of the National Stock Company. Well, two claims are made. One by the
Purushottam Kumar is who?
Uttam Kumar is the, my lord, the claimant.
He.
he and his wife, my
Adequate
lord,
the
both.
trading and demat account on demand by executing a member client agreement according to the agreement. How was the arbitrator appointed?
By the National Stock Exchange, my lord, the arbiter tribunal. And they have won a appellate.
What is wrong in the order?
My lord, the court and Wisconsin is not in consider at all. Party.
So not consider that cannot be a subject matter of a 34.
Well, that is a 34 ground is here, my lord.
Show me that.
Yes.
What is the 34 ground?
Yes.
Non-consideration is not a ground of 34. Non-consideration is not a ground for 34.
In this down, my lord, what can be said, my lord?
Non-consideration of a particular fact is not a ground of 34. Show
No.
me that.
That's not, my lord.
Arbitration act. Where?
Okay. Yes, sir. My lord, without judicial generality of opinion, it hereby declares a favorable doubt and award is prosecuted the public policy of India if making the award is infused or affected by fraud or corruption. Is affected by fraud or corruption.
How?
Well, that is what I am submitting.
No, you are submitting how? How are you saying that it has been fraud and corruption with the arbitrator? Is the arbitrator there is a fraud or corruption.
Yes, my lord, because the false notes were produced before arbitration.
Huh? No,
False-
that cannot be a fraud on the yeah. That is a fraud being committed in the by the arbitrator.
No, not.
Yes, that is it.
My lord, award was induced or affected.
Huh.
Induced or affected by order.
But yeah, the making of the award was induced or affected by the fraud or corruption or was in violation of 75 or yeah,
Right.
in contravention. So you are saying was induced.
Yes, they induced, my lord, because.
What does it mean by induced?
All documents has been produced. Now, my lord, there are two claims, my lord. One by the prosecutor's money, one by the wife. My lord, both, my lord, claim.
No, these evidence cannot be looked into in 34.
I'm not talking that, my lord.
Those documents, whether it has been rightly done or not, whether the appreciation of evidence was properly done or not, that cannot be done in
Not that,
34.
my lord, because the charge sheet was submitted subsequently. And that is why, my lord, if the lord will see the charge sheet, my lord.
Now,
And
did you submit the charge sheet before the tribunal?
Not
And such is just an opinion.
my lord, these has been taken into consideration. My lord. They conspired to make the document, my lord.
No.
And secondly, my lord, one aspect of it is this: appellate tribunal has set aside the award in favor of the wife of Procedural Kawani on the ground that he received some of the contract note. Because in the transaction, my lord, what happened? Our phone, my lord, they make request to purchase some shares. When shares are purchased, these contract notes are sent to them by email, then SMS is sent, then original notes are sent. Here, the claimant himself admitted that, my lord, he has received 6-7 contract notes. Similar allegation was made by his wife also, and that was set aside by the appellate tribunal on this ground, that he has received some contract notes.
Did you produce it in the 34?
Yes,
No, did you say that before in the 34 court?
Yes.
Where is it?
Yes.
Let's
But-
see in your memo of appeal before the 34 court.
Right. Huh? Page 97.
Hmm?
Page 90,
9?
97. It's under the grounds are the at page 10.
Yes.
Good. The allegation and counter allegations of fraud, witness and forgery of documents are detailed in which cited by price complete for the state on side of for the many the same cannot be cited by arbitrator in committee manner. That done by the fundamental of the agreement. Then G, this is the arbitrators have ignored the admission of the number 1 that he has received from contact notes SMS and monthly TP result. Thus, the subject beyond no doubt that every transaction was executed by the considerer number 1 and he was getting the entire information. So him on this ground, you don't think huh? But then everything is there, 8108 K.
No ground.
Those counts are there.
That ground is not there.
Hello?
Wife. No ground.
No, this is my lord.
Where?
As far as I get, because this is the ground, my lord. I think, my lord.
No ground.
No.
Ground?
My lord.
There.
There is no other fraud has not been established. Otherwise, my lord, the whole case centered on fraud, my lord. My lord, nothing has been
And
built.
No. Is that ground there? No.
And secondly, my lord, another aspect from it here. They
Now,
said,
what is the cost to be imposed? 37.
my lord, another aspect here. My lord,
Dismissal with cost. How much?
my lord, that I shall.
This is a big amount, na? Big company.
I shall argue, my lord.
1 lakh.
On Rakesh Das,
Yeah.
from Rakesh Das, my lord, they have shown, my lord, placed a check of rupees 25 lakh.
This is a question of fact. This court cannot,
No.
34 court cannot
My lord,
touch that.
my lord, this,
One has to, Mr. Saiwala, one has to acknowledge 34 court is limited. And 37 is further
no,
less.
34 limited, my lord, 34, but fraud and corruption, my lord, this
Where is the
uh,
fraud? The fraud and corruption is in respect to that award. Where you are inducing the arbitrator. Where is the allegation?
arbitrage is induced by those documents, my lord. And this check, my lord, who is Rakesh Das? They failed to show anything. Who has paid 25 lakhs, that was found. Here they issued notice to Rakesh Das, my lord. That your lordship will
This
see.
is a question of fact. Which question of fact this court is not going?
My lord, your lordship will just see page 95.
95 is what?
There was. Have a look at it.
Yes.
My lord, the paragraph 5.6, the trading member failed to establish basic obligation of proof of placement of the proof of delivery, margin call payment, selling, equity expense. This is not required, my lord. That is not the law. Page 165, that's not the law. This is wrong, my lord. This is not the law. My lord, because he has admitted that he has received some contact notes. In the claim of itself, he has written contact notes has been admitted. So this is also, my lord, the purpose. This was not necessary, my lord.
Perversity is also limited.
My lord.
34 perversity is also limited. We cannot look into all this.
At that time, my lord, page 165, my lord, that was not a. That is a SEBI's, my lord, guidance in 2017. My lord, that was not the necessary.
What do you say about 34B1?
Well, it is correct, my lord. It is not capable of arbitration.
Right.
But my lord, when the serious fraud is there, that is the Supreme Court. Serious fraud is there. All documents are fraud.
Where there are criminal proceedings going on.
Yes, criminal proceedings.
And it cannot be decided.
Yes, arbitration.
Did you raise that point before the arbitrator?
No, my lord, at that time it was not, my lord, the police. Later on, my lord, it came.
No.
So in the 34, my lord,
When it's the case of fraud, you are to challenge the jurisdiction, 16.
my lord, because at that time these things were not there. When they proceed, then only we could lodge the FIR as a then only police investigation, my lord.
So they produced this at the time of filing the claim petition.
My lord, when they filed, then only I could file the FIR, my lord. Thereafter, my lord, the police investigation going on, then charge sheet was filed.
Charge sheet is different.
My lord, correct.
Charge sheet has nothing to do with
No,
that.
that is correct, my lord.
If it is a case of fraud,
Yes.
which is not capable enough, did you raise that issue before the arbitrator?
No, arbitrator, my lord,
challenging the jurisdiction. If you don't do it, how do you take it?
Not have raised at that point of time, my lord. We could not have raised at that point.
There's no way to
And
help
moreover,
you.
my lord, this when contact note, my lord, they have received it. They have received it, my lord. This is established procedure, my lord, that we need not prove it, my lord, because they themselves have admitted. If the lawsuit see the claim before the complaint before the NRC, my lord, at page 139, the last paragraph. They themselves admitted, my lord, similar to it. It is noteworthy to mention that we have received contact note for the above mentioned transaction only from contact note 67 note for the above mentioned trade were received by us. The said contact note was received around 20-30 days after date. Well, email immediately to send. Whenever we received a contact note, we contacted, called him to ask about the matter, but either he did not pick up or misguided, saying that trade was wrongly entered when the account, or excused rectified the same. This is my mistake. And another court, my lord.
Mr. Sayawala, you are only raising on the question of fraud.
Another, my lord. Regarding check, my lord, your losses may just.
No, nothing has been discussed.
No, I shall come, my lord. That has not been discussed, my lord. That has not been discussed. Page 61, your losses may just take. Award, I am going from the award. Your losses may just.
Page
Page 61.
61.
My lord, clause 7, this Roman 7, last 5 sentences. My lord, before a check of rupees 25 lakh was given to the applicant, which would have not been encased, had the check been encased, the dispute would have been ended. But since the stop payment instruction was given to the bank after issue of the check, the same could not be encased, and hence the applicant filed a complaint with the trading member. Well, check, we have not issued the check. My lord, they received one from blank check, they prepared it. My lord, one Rakesh Pal, who is Rakesh, my lord, did not know. They have issued a notice to him. Under 138, page 147, well, then again, well, in para 9, in a small place like Maharashtra, two families are known to each other. It is only natural that the dealings are purely on good faith and trust. There cannot be any reason to disbelieve otherwise. Therefore, their delay in making the complaint process settlement undertaking. Expense was given a check of 25 lakh. In settlement was issued, which unfortunately was not honored. This check has nothing to do with my lord. If you will see 149, my lord, they have issued a notice that who has issued the check, my lord, that check is there, one Rakesh Das. Who is Rakesh Das? We don't know. And Rakesh Das has said that his check was missing. He made some complaint. 144. It's like 149, my lord. 147, my lord. The reply to by Rakesh Das is that.
Who is Thorup Rani Paul?
Urup Hani Pal is my agent. Huh? That.
Hmm?
Special authorized person of the Urup Hani Pal. But his son has, my lord, and check has been issued by somebody, Rakesh Das, with no matter. And that check has been issued, the 138 notice has been issued.
One of the sub broker,
My lord,
Thorup Paul.
yes. Urup, that Swapna Rani Pal, my lord, not Urup Pal. Urup Pal is son. The check has induced the arbitral tribunal, my lord, was the award.
An appeal was filed.
Yes.
What happened in the appeal?
The appeal has been dismissed, my lord.
Did you raise all these points?
Yes.
Then
Then 34.
this is the third, this is the fourth round.
Because
Did they give interest?
my lord, your lordship
Interest is
see
given.
page 147, my lord. The reply by the Rakesh. No, my
Interest?
lord. Page 147. The check, my lord, that check has which, my lord,
No interest.
No interest. Yes, man. The award was pronounced with no interest. Arbitral award.
Now can we give interest?
No, my lord, I think. Because there is a finding.
What?
We have not put under challenge my lord, that issue. Decided against them.
page 147, my lord, your lordship.
Oh no, Mr. Savila, nothing.
My lord, the check, my lord, who is given the check, my lord? I have not given the check, my lord. Lani tribunal has said that we have issued the check of 25 lakh. Had the check been encased, this would have been settled. And the check is, my lord, some check of Rakesh Das. The check also we have an at page 151. And the reply of the Rakesh Das is at 147, my lord. That your lordship must see what he has said.
Is the entire case based on this check of 25 lakh?
Main, this is the main thing, my lord. Check. He said that the tribunal has said that if check would have been honored, the entire dispute would have been settled.
No, that is very good.
Ah.
But is this the only thing?
No, I said, my lord, on the basis of the transaction, my lord, that they have to get it.
Huh?
On the basis of the transaction, they have to get this 50 lakh. Huh? Inference has been drawn. Inference has been drawn from the state. That has also induced the tribunal, my lord. For the award. At page 148, last para, my lord, he has said that he does not know your client. There is no business term with the client at any point of time. The check was missing, that is why, my lord, he got it and I did in this case.
Is the check the only reason? No.
Check is, you him, he said that if a check would have been, encased, it is to settle.
No, that is a different thing.
My lord, but
Otherwise, is the claim made
claim is made,
has
my lord.
anything to do with the check?
No, he said that he has not received the, my lord, that's on to purchase, but he has received 6-7 contract notes. What he has done?
No,
He has done nothing. For that also, he has made a claim, my lord. Because everything, my lord, because as part of, my lord, whenever any order is placed, contract note is prepared, contract note is sent on email, message was sent, SMS also, everything is sent. These things are regular, most of it.
So arbitrator look into it.
This has not been, my lord, considered actually, my lord.
No, consider, not considered is not the question under 34.
Because he himself has admitted that this contract note has been received by
Traveler, one has to understand, you see, there is a very limited jurisdiction.
I understand, my
Can't
lord.
look into it.
But the 34, my lord, has the power to be or admit.
No, nothing. 34 can't look unless you on the face of it. It has to be something error apparent on the face. The jurisdiction is of that. Can't be.
My lord, Lord will see the charge sheet, my lord.
Huh?
If the Lord will see the charge sheet and the tax order, my lord. 122, my lord. And this,
Okay, Mr. I'll hear Mr. Samani. I'm coming in 5 minutes.
My lord, straight line, my lord. Fraud is not the ground essay, my lord, during the, my lord, arbitration posting. Just straight lordship look 49. Against my claim, their reply covered by P, B, case 14.
Yeah.
My lordship, the ground which they have cited here, nowhere reflects any whisper about fraud. Whether they have created certain disputes in regard to the transaction. Even, my lord, at the appellate stage also, there is no any whisper about FIR. My lord. Nothing survived, my lord. If we lordship look into their part, the role at the appellate stage, my lord, page 91. Here also, my lord, there is no need whisper about fraud, etc. Whatever. But the contractual obligation between the parties, if certain parties fail to comply with the terms, whoever their agents, my lord, they are equally responsible for any commission of mistake. There is no need, my lord, recovery suit, etc. filed against that if suppose their agents committed certain wrong. Nothing except FIR.
In the first appeal also, they did not raise the
No,
point of
nothing,
law.
my lord. Even, my lord, kindly see on one aspect is very important. My lord, SEBI's arbitrator are specialized in trading line, my lord. On little emphasize, we can give that they know that how the transaction has moved from one to another place, my lord. Therefore, my lord, we can trust that the findings which has been arrived at through, my lord, forum may not be wrong, my lord, number one. And number two, my lord, the case which has been centered right now, my lord, at under section 37, my lord. Is it, my lord, fair to reopen this all, my lord, disputed facts again to that whether which transaction done by him, which transaction done by us? Bottom line is that, my lord, the arbitrator arrived at a conclusion that transaction which has been carried out by the sub broker who is acting on behalf of,
Award was passed in 2014.
my lord.
Appeal.
Therefore, my lord, the whole case which has been projected based on disputed facts is
Hello.
37.
Let me dismiss it.
This one, my lord, give, go to the chart sheet, my lord. How they have.
No, I'm not going to look into it because you have not raised anything out there about all these things. You are raising it for out here for the
In the, if it says the documents are produced, my lord, then only lodge the
charge sheet is an opinion.
no opinion, but how they have made it.
This is an appeal under Section 37 of the Arbitration and Conciliation Act 1996,
No,
or
no.
short the Act of 1996, challenging the order dated 25/1/2018, asking Ms. J, bracket C, J2 bracket dot C number 135/2014, whereby the application filed under Section 34 of the Act of 1996 was rejected. There's a recent judgment on Section 37. You have got it?
My lord, my lord, about my lord, fourth part, my lord. Fourth part, my lord.
No. Otherwise, Section 37,
Power, my lord.
the power is a very recent judgment on 37. It says it's very limited
My lord,
and is limited in the
to the extent of power.
because you can't treat the Section 37 application is similar to an application under an appeal,
100.
normal appeal.
It is a case of Konkan Railway Corporation Limited, my lord. Versus Chennai Bridge Project 2023.
Hmm?
Konkan Railway Corporation Limited versus Chennai Bridge Project undertaking 2023 live block. Where it is held arbitration award cannot be set aside on mere possibility of an alternative view of the facts of the interpretation of contract. My lord, this I have got, my lord. 2021 judgment. Jurisdiction of High Court hearing and arbitration appeal in distinct from that of first appellate court in a civil suit, my lord.
What is that name?
My lord, the case name is, my lord, Punjab State Civil Supplies Corporation Limited versus Ramesh Kumar and Company. My lord, civil appeal number 6832/2021. Party's name Punjab State Civil Supplies Corporation Limited versus Ramesh Kumar and Company.
Before proceeding on the facts, on the facts leading to the filing of the instant appeal, this court finds it relevant to take note of that Section 34 of the Act of 1996 is a power conferred upon the court to set aside an arbitral award. It is well settled by various judgments of the Supreme Court that the powers under Section 34 conferred upon the court is limited on the grounds mentioned in Section 34, 2B Roman 2. On the grounds specifically enumerated in Section 34. The constricted powers under Section 34 upon the civil court to interfere with an arbitral award is for the reason that when the parties are chosen to avail an alternative mechanism for dispute resolution, they must be left to reconcile themselves to the wisdom of the decision of the arbitrator, and the role of the court should be restricted to the bare minimum. Interference would be justified only in cases of commission of misconduct by the arbitrator, which can find manifestation in different forms, including exercise of legal perversity by the arbitrator. It is also well settled that by the Supreme Court in its judgment in the case of Dyna Technologies P Limited versus Crompton Group Limited, reported in 2019 bracket 2019 20 SCC 1. That arbitral award should not be interfered with in a casual and cavalier manner unless the court comes to a conclusion that the perversity of the award goes to the root of the matter without there being a possibility of alternative interpretation which may sustain the arbitral award. Section 34 is different in its approach and cannot be equated with a normal appellate jurisdiction. It was further observed by the Supreme Court in the said decision that the mandate under Section 34 is to respect the finality of the arbitral award and the party autonomy to get the dispute adjudicated by an alternative forum as provided under law. And if the courts were to interfere with the arbitral award in the usual course on factual aspects, then the commercial wisdom behind opting for alternate resolution dispute would be frustrated. The Supreme Court further, in the case of UHL Power Company Limited versus State of Himachal Pradesh, reported in 2022 4 SCC 116, categorically observed that when it comes to the scope of an appeal under Section 37 of the Act of 1996, the jurisdiction of the appellate court is examining an order, setting aside or refusing to set aside an award is all more circumscribed. In the backdrop of the above, this court therefore takes into account the instant appeal for adjudication. The facts, as could be seen from the materials on record, show that the respondent herein was an investor. Who opened a trading and demat account with the respondent company through its subbroker, one Swapna Rai Paul at Margarita. The said business on behalf of the subbroker was being managed and looked after by one Sorup Paul, her son. The respondent purchased certain shares in the market through the trading member during 2011, 12, and 12, 13 and made full payment thereof. And these stocks were lying in the demat account opened by the respondent with the trading member. It was alleged by the respondent that without his consent, the subbroker carried out certain transactions in respect to his stocks. Without his consent and information.
And authority.
Uh,
Authority, because
Without his consent,
Right.
authority, and information. The subbroker carried out transactions in respect of the stocks of the respondent. On inquiry, it would be learned that the majority of the shares of the respondent kept in the demat account were wiped off due to huge trading loss. Which the respondent did not consent the subbroker to indulge in. Under such circumstances, the respondent demanded the settlement of the account and his entitlement, which was not refused by the petitioners herein, which had resulted in filing of the arbitration proceedings, alleging various illegalities against the trading member, that is the petitioners herein, appellants herein. Upon the filing of the said arbitration proceedings, the respondent, the appellants herein, filed reply stating inter alia that the grievance so set out by the respondent had no legs to stand. The record further reveals that there were various pleadings exchanged thereupon amongst the parties. The arbitral tribunal thereupon framed two issues. That is, whether the unauthorized trade in the F and O segment were carried out by the trading member, and what was the responsibility of an individual investor, and whether he can trade in the F and O segment without keeping proper margin with the trading member. Or in other words, whether a trading member can give margin leverage to an individual investor, and if so, to what extent and what limit. The arbitral tribunal, by an award dated 26/11/2013, opined that the trading member failed in its duty to keep surveillance on its sub-broker and completely failed to comply with the surveillance mechanism and the risk management and the margin requirement, which led to the loss suffered by the applicant, a respondent, due to selling his shares without his consent to adjust the loss occurred due to unauthorized trading by the sub-broker. Accordingly, the arbitral tribunal awarded an amount of rupees 20 lakhs to be paid by the appellant herein to the respondent within 30 days from the receipt of the said order. The counterclaim so filed by the appellant for an amount of rupees 2 lakhs was rejected. Being aggrieved, the appellant preferred an appeal before the appellate arbitral tribunal, raising various grounds on facts and law. The appellate arbitral tribunal, by the detailed order dated 10th of June 2014, dismissed the appeal and confirmed the award dated 26/11/2013, passed by the Learned Arbitral Tribunal, who's being agreed. An application was filed under Section 34 of the Act of 1996 for setting aside the award passed by the Appellate Arbitral Tribunal, as well as the arbitrator, before the court of the Learned District Judge at Tinsukia, which was registered and numbered as Mize case number 135/2014. The said application was dismissed by the impugned order dated 25/1/2018, and it is under such circumstances the instant appeal have been filed. In the backdrop of the above, let this court therefore take note of the submissions made by the Learned Senior Counsel on behalf of by the Learned Counsels appearing on behalf of the parties. Mr. G.N. Sahewala, the Learned Senior Counsel, submitted that this is a fit case for setting aside the award in view of the provisions of Section 34(2)(b)(1). 2B(2). In view of the fact that the award was induced or affected by fraud or corruption, the Learned Senior Counsel submitted that there were serious cases of fraud being committed by the respondent hearing by submitting various fraudulent documents, and on the basis of such fraudulent documents, the award was passed, which, and as such, the said award so passed was in conflict with the public policy of India. He submitted that the appellant have filed an FIR against the respondent, and the same has been duly charge sheeted. The Learned Counsel, Senior Counsel, further submitted that this very aspect of the matter was not taken into consideration by the Learned Trial Court, by the Learned District Judge, while passing the impugned order, for which the impugned order requires to be interfered with, as well as the award be set aside. Anything else?
As per established law, my lord, the tribunal state would say to copy, my lord, but in fact, documents were sent to me, my lord. It's contact notes by SMS, and he has admitted that.
No, fraud. Anything else?
Fraud, my lord, this is the fraud.
Huh?
This is the fraud, and there, my lord, with the son of the, my lord,
Did not consider properly the evidence on record. Is it your second submission?
Yes. This is the second submission.
The Learned Senior Counsel further submitted that the Learned Arbitral Tribunal did not consider the relevant evidence which would have shown that the respondent herein had due notice of the trading as much as he has received the SMS and contact rules, contact norms, and contact notes, contract notes. And this very aspect of the matter was neither considered by the arbitral tribunal in the proper perspective and was not at all taken into consideration by the learned district judge while passing the impugned order. He therefore submitted that this is a fit case for setting aside the arbitral award. On the other hand, Mr. S. Samaria, the learned counsel appearing on behalf of the petition respondent, submitted that the question of fraud which have been alleged by the learned senior counsel has been first raised before the court in the proceedings under Section 34. The question of fraud or any fraudulent documents were never raised before the arbitral tribunal, as would be apparent from the materials on record, including the details so mentioned in the arbitral award. The learned counsel further drawing the attention of this court to the judgment of the Supreme Court in the case of UHL Power Company Limited Supra, submitted that the question of interference to an arbitral award cannot be casual and in a cavalier manner. The learned counsel further submitted that the perversity which has to be shown in respect to the award has to be such a perversity which goes to the root of the matter, without there being a possibility of alternative interpretation which may sustain the arbitral award. He therefore submitted that this is a fit case for dismissal of the appeal with exemplary cost, taking into account that since 2013, the respondent herein have been deprived of the fruits of a lawful award. Anything else?
Enough.
I've heard the learned counsels appearing on behalf of the parties and given my anxious consideration to the aspects, to the submissions so made. Let this court first take into consideration the first contention made by the learned senior counsel as regards the award is in conflict with the public policy, primarily on the ground that the award was induced or affected by fraud or corruption. From the submissions made by the learned senior counsel, the fraud which have been alleged, which have been used by arbitral award, is in respect to documents of fraud being submitted, is in respect to fraudulent documents being submitted by the respondent before the arbitral tribunal. The allegations of fraud is not on the arbitral tribunal committing any fraud. This court had duly taken note of the arbitral award dated 26/11/2013, wherein the learned arbitrator have duly recorded the stand taken by the appellant before the arbitral tribunal in its reply as well as in its rejoinders. There is not a single whisper in the said reply as well as in the rejoinder as regards any allegation of fraud. This court further takes note of that in the appeal which have been filed against the award dated 26/11/2013, there is no whisper of any allegation of fraud or any fraudulent documents being submitted. The entire allegations which have been mentioned against the award dated 26/11/2013 is that the learned arbitrator did not take into consideration the various materials on record in the proper perspective. Under such circumstances, in the opinion of this court, the said submission made by the learned senior counsel is totally misconceived inasmuch for the reasons aforementioned. This court, this leads this court to take into account the second contention so advanced by the learned senior counsel that various relevant documents, that is, the SMS as well as the contract notes, were not taken into consideration by the learned trial court, consideration by the learned arbitrator, as well as the appellate arbitral tribunal, while passing the impugned awards. This court finds it very relevant to take note of that It is relevant to take note of that non-appreciation that the court under section 34 of the Act of 1996 cannot reappreciate the evidence. The contours of the jurisdiction under section 34 can be only exercised if there is a patent illegality or a perversity which goes to the root of the jurisdiction, root of the matter. This court at this stage finds it very relevant to take note of the judgment of the Supreme Court in the case of Delhi Airport Metro Express P Limited versus DMRC, reported in 2022 1 SEC 131, wherein the Supreme Court
Well, this judgment has been overruled.
this is that judgment. Recently, a review was done.
Yes.
The 1200 crore thing.
800
No, more than that. 7,000 crore.
7,000. Yes.
7,000. Authentically लिख ले अपनी। हाँ, तो तुमको सुनने ले। On perversity and error which goes to the root of the matter. हाँ? It is well settled that patent illegality, that the expression patent illegality should be illegality which goes to the root of the matter. In other words, every error of law committed by the arbitral tribunal would not fall within the expression patent illegality. In addition, contravention of the law not linked to public policy or public interest is beyond the scope of the expression patent illegality. It is no longer res intriga that the courts, while taking up an application under Section 34, is prohibited to reappreciate the evidence to conclude that the award suffers from patent illegality appearing on the face of the award, as the court do not sit in appeal against the arbitral award. This court has also duly taken note of the arbitral award passed by the learned arbitrator dated 26/11/2013. And from the above, this court does not find any patent illegality or perversity. Within the meaning of touching to the root of the matter. Consequently, this court does not find, no. In addition to that, this court also finds it relevant to take note of that the learned district judge, while it ordered it at 25/1/2018, have duly dealt with the application under Section 34 of the Act of 1996 in the manner as stipulated, in the manner well settled by the various principles of law, principles laid down by the Supreme Court. Under such circumstances, the question of interference by this court to the said order does not arise, for which the appeal stands dismissed with cost quantified at rupees 1 lakh.
My lord, in our view, it is minimum because we are not entitled to get interest, my lord. And this one, they can pay, my lord, also. This is a company, big company.
22 crore, 25,000. Cost quantified at
Another matter, my lord, the Software India case, my lord, you are also directed to this in the top of the matter.
which
At
one?
top of the list, item number 8, my lord.
Oh, yes.
My lord, but it is not listed top of the list. Today also, my lord, it is there. So
Oh.
any date may be fixed, my lord. Again, my lord.
Mr. Odhikari is ready.
Yes, sir.
Hello? Let's hear it. Others may go. Any other matters? No? What is there? Yes, Mr. Paul, what is there?
Huh?
What item? Lagi bahasa ni.
Item number 6.
6 and 7 itu ke mati delay. Deal tu jalan. And this review petition, who is there? Anybody in the review? Yes. What is your case? There's some problem with that. What, you are there in the review petition? What is that? Why have you filed a review? Oh, that problem.
Yes, Lord.
Making somebody a party.
Not that.
Which one?
Lordship, actually on the date of hearing, the engaged counsel of the petitioner did not appear in the case.
Then?
That is why some vital aspects of the case did not be placed before the court.
Then?
That's why this review is being preferred.
Review you can't file like that. Where is the error apparent? First of all, don't take the chance of not be appearing before the court.
On the last occasion, we were directed to produce the status of the NIT, Lord.
Oh, yes, I remember. The NIT.
Yes, Lord.
Now, what has happened?
Lordship, almost not 80% work is complete, Lord.
Then, what is the review?
Lordship, actually the manner in which the petitioner was disqualified from the tender.
So, what do you want to do now? Go and file a civil suit against them. Yeah? That is why I asked you, what is the stage? Because this was done after a long time. Now, review continue. Just 1 minute. Let me finish off the review. Okay, Mr. Sahewala, your matter will have it some other day when? Next Tuesday. Okay, next Tuesday. Good. Top of the list. Madam, were you blacklisted?
Lordship, the blacklisted was done after.
Was it the case of blacklisting?
Lordship, actually the blacklisting order was passed after this tender. It was the tender process was conducted in the year 2021 and the petitioner was blacklisted in the year 2022. And against that blacklisting order also he has preferred a writ petition.
Then?
Which was due for hearing today in court number 4.
So what is there to review?
If the tender bid documents was rejected on the ground that scanned technical document was not attested by the petitioner. But in the bid documents, Lordship, as per clause 17 and 18, nowhere it is mentioned that scanned technical documents need to be attested. Only the hard copy needs to be attested, which was duly done by the.
No. Show me that. What is the requirement?
Lordship, page number 87, clause 17, format and signing of the bid.
Yeah, page 85.
Page 87.
Come to 85 before. Photostat copies, scanned copies duly attested by the are to be submitted. Then the bidder need to upload all technical as a single file document, as a single PDF document. Then 86. Including a hard copy of the technical need to be submitted with self-attestation in the case of a hard copy submission only, and in case of soft copy online mode, the bidder need to follow the instructions mentioned above under clause special information. One, technical bid one for submission through online and another for manual submission in the year which in the last date. Then B 86. Capital B. Capital B. How do you take care of that? You had 1 to 57 page. They had on which have been uploaded. Tell me, how do you take care of that? And 80% of the work has been done. Have you been blacklisted? You can't be blacklisted for this. Have you been blacklisted for this?
Not for
No,
this,
no.
I suppose, Lordship.
Lordship, the blacklisting was done after this.
No, nothing to do with this contract.
No.
Then 80% of the work is being done. What do you mean? See, the reason why this has been done because there was no stay also. In the writ petition, there was no stay. That was one of the reasons. Keeping you out here unnecessarily doesn't help. Let's see. According to director status quo as on July as regards the execution of the work or remand or shall be maintained till so and so. Oh, this is the sluice gate thing.
Yes, sir.
That problem which happened because of keeping the matter pending for all this while. I think this is the case. Yes. Is it the case? Huh? See? You did not appear on 31.5. As you did not appear, I fixed it on 1.6. You did not appear on 1.6. Then I kept it on 1.26. Then how much time do you need? Today I have given very less cost. Till late, today I have only imposed 40,000, 25,000, another 15,000. Let me make it under 60 and make the 1 lakh daily 1 lakh. 80% work done.
Yes.
This is the sluice gate one. Court is not going to review. Nothing is infirmity. And there was a lot of stay because of that. No? This has sluice gate at Pandugar Mandi. Yes, I remember this matter. Some problem with this. Why? Yes. The stay was going from 4/1/2022 and nothing happened out. This is the reason why. These matters came in the top of the list. In appeal, can't help it. And in fact, you see, on 30/5/2023, Mr. R. Sinha appeared. And you have received back the EMD.
Yes, Lordship, it is automatically refunded back
Yeah.
after the award of contract.
And as on that date, you were blacklisted also.
Yes, but blacklisting was done in the year 2020.
Maybe, but then also this contract couldn't have been granted to you. Anyway. Hello. Okay, we dismiss it. This is an application seeking review of the judgment and order dated 2/6/2023, passed in WPC number 3025/2021. The grounds of review which have been taken is that the council for the review petitioner could not place the materials, could not make the necessary submissions in the matter as he was absent. This court have duly taken note of that the matter pertain to a contract for construction of a sluice gate at Panduna Mandir area to check the backflow of river Brahmaputra. Pursuant to the tender being issued and the rejection of the bid of the petitioner, the writ petition was filed, and by an order dated 11/6/2021, a stay was granted. An interim order was passed directing to maintain status quo as regards the execution of the work in respect to the construction of the sluice gate at Pandunath Mandir area to check the black flow of the river Brahmaputra under Guwahati East WR Division. Thereupon, the interim order was extended from time to time. Full stop. It, however, is seen that on 16/12/2021, when the writ petition was listed, this court directed the matter to be listed on 4/1/2022, and the interim order passed earlier was directed to continue till the next date. However, on 4/1/2022, the interim order was not further extended. Thereupon, the matter was listed on 30/5/2023 wherein the counsel had duly appeared on behalf of the petitioner. Full stop. And on that date, the counsel appearing on behalf of the petitioner sought an accommodation so that he can take appropriate instructions from his client. And this court fixed the matter on 31/5/2023. The record further reveals that on 31/5/2023, 1/6/2023, as well as on 2/6/2023, the petitioner, counsel for the petitioner did not appear. Although the said matter was duly listed, showing the name of the counsel for the petitioner. This court further, taking into account the materials on record, had passed the judgment on 2/6/2023. Under such circumstances, in the opinion of this court, the question of there being an error apparent on the face of the record or the condition of sufficient cause does not appear in the instant proceedings, thereby to review the judgment and order dated 2/6/2023. Accordingly, this court further finds it very relevant to observe that pursuant to the order date passed on 2/6/2023, the said work pertaining to the construction of the sluice gate at Pandunath Mandi area to check the backflow of river Brahmaputra commenced, and today when the matter was taken up, Mr. P. Sharma, appearing on behalf of the Water Resource Department, submitted that as on 22/4/2024, the physical progress of the work is 80%. Considering the above, this court is of the opinion that this is not a fit case for review of the order, judgment and order dated 2/6/2023 for the grounds and reasons stated herein above, including the fact that already 80% of the work has been completed. The learned counsel appearing on behalf of the review petitioner, however, further failed to show any other grounds. Accordingly, the instant review petition sent dismiss with cost quantified at how much? 45, no? 55. Yes.
I am 40.
Yes, tell me. We'll just start and then we'll hear it again.
Now, petition is against the for me.
Huh?
The respondent is for me.
You come here. Yes. Dutas.
Six center.
Girish Kulita?
English college.
Girish Kulita.
Huh.
Okay, there are two appeals. Why?
Now, my lord, in this two appeals, the committee is still up. Pani Kema Town Safar.
Ah,
Now, in the actually the president and the secretary and another member are already
who had expired?
president, secretary, President Madhav Kolita. He has been active. Secretary Shantiram Kolita, he is also
Santiram Kolita. Okay, no problem then. Other members are there.
other member, another member is also
Represented, this committee is represented by the president. Number 8 is there.
President and secretary.
So here, you see, it will be a provision of our under 22 rule 10. This
No,
would
my
not
lord.
come.
It would not come under order. Because under order 22, only legal heirs are
Understood. Therefore, it may be a case of assignment.
assignment. It would come under order 1. If I am not wrong, under order 1, rule 8.
No. Order 1, rule 8, if you want to bring in, you have to bring in, go for a public notice.
No,
That is not order 1, rule 9, because there are Supreme Court judgment, I think in 1973-74, there is a clear-cut judgment on this. I still remember the name of the case is Santram. The question involved out there was that this person happens to be the Mahant of some town temple. The temple was filed, the suit was filed against the temple represented by the Mahant. Now this Mahant person died. The trial court, high court held that order 22 rule 4 would apply and abated the suit against him. And accordingly, the suit was dismissed. The matter went to the Supreme Court. The Supreme Court says, yes, it has otherwise abated, but this is not a case where it will come within the ambit of Order 22 Rule 4, but it will come within the ambit of Order 22 Rule 10. And it will be an assignment and where there is no limitation. And as such, there is no problem with that because it is something, there cannot be a legal representative of a president. If you see the president, the legal representative concept, which is expanded to section 219, is a person who devolves upon the estate of the deceased. Now, he cannot be it cannot be a part of his estate of a dead person. So therefore, it cannot be under Order 22 Rule 4 or 3, if it is the plaintiff, it has to be under Order 22 Rule 10. So merely a simple application can be filed, bringing in record that this person is now dead.
President and secretary.
There's no problem with that. Only you need to just bring an application under Order 22 Rule 10. There's no limitation also. You want the judgment, Santram?
Organization is already there on record.
Eh?
That organization is your party.
And that too represented by the
party.
president. Give you the judgment. In fact, I didn't know that. I was doing one matter of
New president would not come.
that is why the president will come within in the scope of Order 22 Rule 10.
Actually, presidents change yearly. They are changing yearly. Every year they are changing. Every year they are changing.
Otherwise, it will have a huge problem.
Yeah.
Now tell me, what case you have?
In both the appeal 95 and 96, both environment.
My lord. Me another time.
Okay. You are not in a hurry. Yes, just give me a glimpse of what is the case, Mr. Sharma.
My lord, even peacefully, purchased that by a registered when he was minor, and the land was temple, and the tenant, occupancy tenant, Kotian holder, executed the service in the part of the
Tenant.
tenant. He is a occupancy tenant, Kotian holder. He executed the service in favor of the
In favor of the plaintiff.
plaintiff.
Okay.
And hereafter, the land was made Sarkari under the provisions of Assam Religious Endowment Act.
Ah.
Originally, it is a temple land belonging to the Mananda temple. So, under the Assam State Acquisition of Land,
So it was not a registered sale deed.
he was a registered
So he sold his occupancy right.
occupant.
Okay.
And when he was a tenant, and subsequently, the land was acquired.
Hmm.
And the name of the applicant was also recorded as the potter.
So it was done under the Charitable Institute Endowment Act. Yeah. Then
some state acquisition of land belonging to the religious and physical. So, subsequently,
Hmm.
when the land was secured under that provision, the tenant became the potter.
Hmm.
And he also executed a gift in favor of
plaintiff.
me.
In favor of the plaintiff or the committee.
Defendant.
Then you filed a suit.
Then subsequently, I was disposed from that. That is why I thought.
That's what. So your suit was initially dismissed.
Initially dismissed.
Why there are two appeals? There's a counterclaim.
The counterclaim is also defeated.
Why
My
there are
suit
two
was-
appeals?
My suit was initially dismissed by the trial.
Hmm.
Thereafter, I preferred it. And in appeal, the appellate court framed an issue and sent back the case. And subsequently, the trial court also dismissed my case. And thereafter, again, I preferred it. And thereafter, the case was remanded on the ground that the appellate court framed the issue, and that was not cited by the trial.
Hmm.
And thereafter, the suit was defeated in my case.
Hmm.
Thereafter, they preferred appeal, the appeal, their appeal was allowed.
Yes, this is online no mark. Hello. So when do you want to do? No, I two appeal. One is title appeal.
95.
There were two
Or
suits. There were two suits. That's why.
two suits.
There were
Yes,
two
Mr. Sharma, tell me why there are two appeals?
There were two suits, right and lowest.
Who filed? Two suits.
They have filed two suits.
Why they filed two suits?
One for 5 places of
One
land,
for
another
5
for 10
places
places of
land.
land.
And subsequently, I was also disposed.
Actually, they have filed for
10
5 places
places.
of land,
Another 10 lesser.
another 10 places. There's but two suits.
And he purchased how much land
15 places.
initially?
15
15 lessers.
There it is 15 places.
I purchased 1 bigha, 1 kata, 19 lessons.
Okay. So you have been dispossessed from 10 lesser and 5 lesser.
15 places.
Remaining you are there. You have challenged the gift deed.
I'm not telling the
No, not challenged. Now, the trial court decided both the suits in his favor.
Yes. There were several times remands were there. Firstly, trial court decided against him. Matter went to appellate, first appellate court. Again, there was remand. In remand, again it was decided against him. Again, there was remand. In
No,
this third time, it was decided in his favor.
The trial court decided
In his
both the
favor.
suits in his favor.
In his favor. Thereafter,
Appellate court decided in your favor.
in my favor.
And against this, there are two appeals.
Against them. In whole question, they alleged to have purchased the land from one occupancy tenant. It will be covered under the Act of 1935. So whether that occupancy tenant has rights to transfer the land, that is another issue. Whether the land which they alleged to have purchased, that is the suit loan, that has to be decided. Whether the land which they alleged to have purchased, that is the suit loan land or not, that has to be considered.
But that's a question of fact.
Yes. And then no, then again
under section.
Again, whether the
Both the cases, the question of law remains to be same.
Same.
Because he must have passed the same order.
Why tell
Com-
it
common
was in
judgment is here.
1967?
Because
Common
both are
judgment is here.
together.
Common judgment is common judgment.
Then we'll do one thing. Are you going to file that application? You have not necessary. I think response number 8 is already there.
Represented by President and Secretary.
Huh?
Represented by President and Secretary.
It will keep on changing.
It will go on changing. Each year they are changing.
When did he die? Who is the present
I
president
do
and
not know
secretary?
exactly.
Actually, I also do not know who are President and Secretary. I have to talk to them.
Now,
They
burden
have
lies
lost-
upon him to inform the court.
Huh?
Burden lies upon him under order 20.
No. He can very well inform one thing, not other aspect. Because he is representing this, na? Respondent number 4.
Yes.
Respondent number 4, if he is representing,
Definitely, I can inform our President and Secretary. I can take information.
so we'll have it on when? Next Thursday? Not this, the next one. Okay?
After 2 weeks.
You want to do after 2 weeks? So old matter, 2010 matter,
At any time, I have no problem.
12 matter,
I am there.
14 years have gone by.
I am there.
You want to have an early?
At least 2 months time,
Huh?
2 months time,
2 months time for what?
because I have come newly in this case. So I am to be prepared. I have to go.
My Leonard he appeared in trial court also. He is
No,
appeared
I
in
am
trial
not
court
trial
also.
court, but I appeared in the first appellate.
He is appeared in first appellate court.
I'm having it on next Thursday, on 2nd of May. Yes. Huh? No, let us have it on 2nd of May, when Mr. Sharma will give the names of those persons who are present. Mr. Paul, kindly listen. On 2nd of May, he will have it on 3rd of May. On the 2nd of May. He will give the details of who are the persons who are presently the president and secretary.
Yes.
And on the basis thereof, I will inform you, you will file that application.
Yes.
And then bring it, and then we will have it on 3rd. A small application, 1-page application. That needs to be, records needs to be corrected, that's all.
Then we pick that.
Mr. The learned counsel appearing on behalf of the appellant submitted that the president and secretary of the committee, the respondent committee had expired, who were arrayed as the respondents in the instant P. Taking into account that the post of the president and the secretary are not hereditary, but are posts which are elected. Elected. The provisions of Order 22, Rule 3, Rule 4 of the court shall not apply. And in such circumstances, the provision of Order 22, Rule 10 of the court shall apply. Mr. S. Sharma, who represents the respondent committee, shall apprise this court on the next day, as who presently is the president and secretary of the said respondent committee. List the matter again on. Let's have it on today, Jayana. Let us have it on 3rd of May.
Yeah.
3rd of May, you just get that information.
my lord.
Thereafter, we
In-
take
In
it up.
RSA
On
95,
3rd of,
in
huh?
RSA 95, 2%, in RSA 95, 2% expired. In RSA 93, apart from president secretary, one member is also there. Number
Member,
7.
it's okay.
That can be,
Well,
they can strike out the name of the member.
Not actually.
We'll
They
do
can strike out the
nine.
name of the member.
We'll do whatever. But
That's
you
what number
just
7.
find out that one. Because his allegation is against the committee.
Yes.
On 3rd. You just get that information. Then he
Sure,
can
sure.
file this necessary application and we can do it.
Definitely, yes, sir.